Good afternoon, everybody. I'm going to ask if our panelists can come up for the first panel. Welcome. I'm Brad Saxton, the Dean of the Law School, and just delighted to welcome you here for this symposium of very, very interesting topics and a terrific panel. I want to welcome our panelists and thank them for joining us. We have so many other distinguished guests that I'm not going to try and go through and single folks out, and just to say everybody here is distinguished, and we're delighted to have all of you here. And I'm glad we didn't get snowed out. From the law school's perspective, we are really delighted to be able to participate in this kind of event. I'm very pleased to see so many of our students here. I'd like to thank our Criminal Law Society and our Student Bar Association, and Nicole Hernandez in particular, who work with Jeff Meyer, whom I'd also like to thank. Where's Jeff? Jeff? Hey. For the great work in putting this together, and Sarah French Russell, our newest professor. Delighted to have you moderating the second panel. So, from the law school's perspective, this gives us a very nice opportunity for our students to work with us and working with the bar and the judiciary on issues of importance to the profession and to the administration of justice. We're especially grateful for a very strong partnership that we have with the Connecticut Bar Foundation, who's co-sponsoring this event. From the dean's perspective, students, we love these kind of opportunities for you to see what you're learning in the classroom brought to real-life problems and practical problems in the administration of justice and how that works. So I really am grateful for your being here and your involvement in helping put this together. With that, I'd like to introduce my very good friend, Tim Fisher, the president of the Connecticut Bar Foundation. And just as a side note, I'd like to thank Tim, who is serving with us at Quinnipiac this year as a distinguished practitioner in residence, guest appearing in a number of our classes and working with a number of our professors to bring in perspectives from practice that are helping us a great deal. So Tim, thank you very much.
Well, thank you so much, Dean, and to the university for helping us put on this program. So much credit goes to Professor Jeff Meyer, who's organized this, and it's our great honor to be a co-sponsor with the university. The mission of the Connecticut Bar Foundation is to further the rule of law in society and to assist in efforts to improve the administration of justice. And we do that in part through our role as the primary funding source for legal aid in Connecticut, because we believe that the rule of law, to have its full meaning, requires that one have access to the benefit of legal representation regardless of resources or one's power. And at the same time, we engage in programs and help with programs that explore how the rule of law can be improved. And this is squarely within that effort, and we deeply appreciate the opportunity to be part of this effort. It's especially great for us to do this in partnership with Quinnipiac University School of Law. The Academy is a place of such great intellectual energy and curiosity, and a space in which ideas can be explored of the sort that we have here today. So thank you, Professor Meyer, for organizing this, for assembling a truly distinguished panel, and we're pleased to be part of the effort. Thank you.
Thank you, Tim. Thomas Jefferson famously declared that trial by jury is the only anchor yet devised by man by which a government can be held to the principles of its constitution. It's no surprise that the right to a jury trial is triply enshrined, twice in our federal constitution for both civil and criminal cases, and once in our state constitution as no less than inviolate. Not just a constitutional artifact, the right to a trial by jury remains vital and fundamental in our popular culture and the public's perception of what it means to achieve justice. So we might all agree on the benefits of a trial by jury, but great differences, I would suggest, still divide us in terms of just what the right to jury trial means and what it ought to mean. Today, in our limited time, we'll explore two aspects of this question. Our first panel here will look at how we pick our juries with a focus on Connecticut's virtually unique system of individualized questioning of prospective jury members. Now, some here will question the cost of Connecticut's exceptionalism here, and others will affirm it. Underlying these cost-benefit arguments, I would suggest you'll see deeper differences of normative perspectives about just what a jury trial right should mean. Our second panel will shift from how we pick juries to what juries ought to do when called upon to decide cases. Although juries live today in popular myth as the conscience of our community, the reality is different for most criminal cases where jurors are relegated to deciding just what the facts of a defendant's guilt are rather than what punishment a defendant should receive. Even after the Apprendi Revolution, juries don't necessarily decide all the facts that matter to what sentence a judge will ultimately impose, and they are foreclosed usually even from knowing what possible sentence a defendant might receive in the event of a conviction. But then again, substantial arguments can be made that maybe lay jurors are not as well suited as expert judges who see many more cases to deciding what it is a sentence that a defendant should receive. Our panelist on the second panel will explore whether we've got it right as we do it now, or if we ought to rebalance the role of juries versus judges at criminal sentencing. Now, I could go on at great length about the extraordinary qualification of our panelist here today, but I'm going to leave that to your written programs, which, by the way, as you'll see from the small print, was designed by the Connecticut Ophthalmological Society. I see, however, that we are joined today by a number of leaders in the legal community, including at least two members of the Connecticut's General Assembly and the Judiciary Committee, Senator Edward Meyer, who most of you may call Senator, and I've been calling Dad for the last 47 years, and Gary Winfield Holder has also joined us today. And in addition to the remarkable background that our first moderator, Mike Lawlor, has as 15 years as a chair of the General Assembly Judiciary Committee, we can be confident that the views expressed today will perhaps have some resonance at some later time in Hartford. We're also joined by a number of other judicial and public officials and some of the top practitioners from all over the state of Connecticut. And we're just so very lucky, and our students are so lucky to have you here today. And I hope you'll get the chance during our break to get to know some of our students a bit better. That gets me to the word in terms of our format. We will plan to go for about the next hour and 15 minutes or so, depending upon how contentious the panels get, on the jury voir dire issues and subject to our chairman's discretion. And then a substantial part of that, the panelists will be speaking just 10 minutes each. And then the moderator will add any additional comments or questions they have, and then solicit questions from the audience. That will be followed by a coffee break, a short coffee break, and then to our second panel. So without further ado, I'm very glad to introduce Mike Lawlor, truly a legend in criminal justice policy issues, now today with the Connecticut Office of Policy Management. We're very lucky to have you here, Mike. I'll turn it over to you for the first panel.
Thank you, Jeff, and good afternoon, everybody. Thanks for coming. You know, there's a good crowd here, but the great news from my perspective is that we're also joined by not only the Quinnipiac University broadcast organization, but Connecticut Television Network, CTN, who will be broadcasting this. And I learned from experience many years in the legislature that there are actually thousands upon thousands of people who watch these types of deliberations. And I think what we say here will help inform the views of many people throughout the state who might start out thinking this is just some legal technical discussion that we're having, but we'll come to find out in the next few minutes that this is a very emotional topic among legal professionals about whether or not to make a change in something that has been of long standing in our state. So I hope if this is going to come before the General Assembly as a legislative proposal, which I suppose it might, that people spend some time thinking about this, because these are very, very important concepts that we're discussing here. Now, I do have a new job. I work for our new governor, and I think if he were here, he would say that every crisis is also an opportunity. And the mantra of the new administration is doing more with less. We are facing an extraordinary fiscal crisis, but at the same time, there's many things that ought to be changed in our state. And I think some might argue that the discussion we're about to have might be relevant if you're looking to have a more efficient court operation. But saving money isn't the only principle. Obviously, better, fairer, more just outcomes is just as valuable a goal to have. And so there is this, the battle that we're about to see unfold. And finally, let me say one thing. I learned over many years of going to forums like this in other states that each state is truly unique. And Connecticut is unique in many, many ways. Not just this issue about individual voir dire, but in many other areas where I think we could take some pride in the fact that we do stand out among the states. We don't elect our county sheriffs. We don't even have county sheriffs. In fact, we don't even have county government. That's very different. We don't elect our prosecutors. We don't elect our judges. So in those ways, we have a very different justice system. And in this way, we are virtually unique in the nation. So I'll leave it to you to decide whether this is good or bad going forward, but it's very interesting and it's very unique. So we have a panel of experts, each of whom is very opinionated on this topic. We've saved the defense of the current status quo system for the end, but we'll go in order of people who have published, who have spoken out in favor of change to our current system. So first is Judge Carl Schuman.
Thank you, Mike and Jeff, Dean Saxton. I think, as Mike and Jeff said, one thing we all agree on at this table is that Connecticut's method of jury selection is unique. Indeed, Connecticut is the only state, or including the federal court's jurisdiction in the country, in which jury selection is mandated by statute or constitution to take place outside of the presence of other jurors, so that state statute requires that the questioning of each juror take place outside of the other jurors. Although Mike said it has a long history, the fact is that it has not always been this way, and really Connecticut has a longer history without individualized voir dire than with it. For most of our history, voir dire was not required to take place in this way, and it took place in a variety of ways, including panel voir dire, which is what most of the rest of the country does. In 1972, we enacted a constitutional amendment that did say that the right of parties to question jurors individually shall be inviolate. But 5 years later, the Connecticut Supreme Court held that panel voir dire is consistent with that amendment. And so, in other words, as long as lawyers could question jurors individually, the fact that the jurors or prospective jurors were in the box satisfied the Constitution. That was 1977, in which the Supreme Court upheld panel voir dire as consistent with our state constitution. At the same time, the legislature enacted Public Act 77-255, which is the predecessor of the current statute and does require that jury selection of each juror and questioning take place outside the presence of the others. So it's only since 1977 or so, approximately 34 years, that we've had the current system. As a result of the fact that Connecticut is unique in the country in having this system, we have some unique results. And if we could see the first slide, I can't see it too well, but this, I think, tell me if I'm wrong, is a graph entitled State-by-State Comparison of Length of Voir dire for Felony Trials. And you'll see Connecticut is all the way over on the right, just about off the chart, because we are the slowest jurisdiction in the country in selecting jurors. And according to this survey, which was done by the National Center for State Courts in 2007, the average time for selecting a jury in a felony case is 10 hours of jury selection. I think practitioners here will say that that's a very low or conservative estimate, and that in many cases it takes much more. But in any event, as the chart shows, we are twice as slow as the 49th slowest state, which is California, and all the other states take from 5 to 1 hour to select a jury in a felony case. If we can go to the next slide and see a comparison in civil cases, you'll see that the results are even more disparate in that, according to this survey, the average time it takes to select a jury in civil cases in Connecticut is 16 hours, and I think practitioners here will all attest to the fact that it does take longer than that in many cases, whereas California, again, is the 49th slowest state. It takes approximately 4 hours there, so we take 4 times as long as the 49th slowest state to select a jury in civil cases, and every other state is under 4 hours. These figures are averages. They may differ in various cases, but I think you get the point that that Connecticut is just off the charts as far as the time it takes to pick a jury. What I have proposed in an article that's co-authored by retired Justice Borden is that we amend the statute and go back to the system we had, which was one of panel voir dire. We're not proposing to amend the constitutional amendment. I think Connecticut has a good system in allowing lawyers to ask questions of jurors. And it's not necessary to amend the Constitution to go back to the panel voir dire system. As I've said, the Supreme Court has upheld the constitutionality of it. Now, we're going to hear a lot of concerns about eliminating the individual voir dire system, and I think the concerns are valid, but I think that our proposal addresses them. Certainly, there is a concern that jurors in a box will blurt out some remark that might taint the rest of the panel, or perhaps the opposite concern, that jurors won't be forthcoming in telling us about biases or prejudices that they may have. And these are valid concerns, but I think they can be addressed with a panel voir dire system. Personally, I use written questionnaires that help pre-screen jurors and ask questions. Is there any reason why you think you could not be fair and impartial in this case? Knowing the charges or the allegations, is there anything would there be anything that would make it especially difficult for you to sit on this case? In other words, any issue that touches too close to home. And we've been able to carefully pre-screen jurors so that jurors who are left are relatively free of concerns that touch closely to the case. If a juror in a panel who has already been pre-screened still does have something that they might be reluctant to say or that might prejudice other jurors, in a panel voir dire system, there would be discretion for the judge to say, we'll interview you after we talk to the other jurors, or could you come over to the sidebar and we'll discuss it at the sidebar. There are ways of addressing these problems, and indeed, every other state in the country addresses them. So it can't be that our system of individual voir dire is the only system that eliminates prejudice and bias in jurors, or that eliminates the risk of tainting of jurors. It is not a serious problem elsewhere. The individual voir dire, in my view, is perhaps unnecessary or overkill to address these problems. We can address these problems and still achieve the savings by going to a panel voir dire system. In our article, we calculate that we could save $1 million a year in criminal cases by going to a panel voir dire system. And I'm not here to say that that is the main reason why we should change our system, but I think any responsible legislator or taxpayer should take note of the fact that it's an added benefit, and it's if there are no costs in terms of the fairness of the system, then why not achieve that benefit? There are other benefits to the panel voir dire system, and I'll just summarize them and then we'll go on to the next speaker. But certainly it takes much less time for the lawyers. Importantly, it's much less trauma for the jurors. And we have to consider the jurors' interest in this issue. I've spoken to jurors, and some of them are comfortable coming out and being voir dire individually, but some of them feel like they were on trial, and they're uncomfortable talking about important issues when they're in the witness box, being interviewed by lawyers with a judge there and person charged with serious offenses sitting 15 feet away. For many jurors, that was a very stressful experience. In the panel system, lawyers get to see who is next. In the individual voir dire system, you're questioning a juror. You, as a lawyer, you see some problems with this juror, but you only have so many peremptories left. You don't know whether the next juror is going to be better or worse. Might turn out to be worse. But in the panel voir dire system, you talk to all the jurors, and then at the end of the examinations, then you exercise your peremptories so that you see who is next, and you can exercise your peremptories wisely. There have been no studies anywhere, and this would be a difficult thing to document, I realize, but showing that a jury selected with a panel, and the panel voir dire method is any less fair than a jury selected with individualized voir dire. My experience is that you know whether a juror is going to be fair and impartial within the first minute or two. And after that, lawyers are just asking the same rather routine questions to the jurors. There's no reason, in my view, not to ask these questions with all the jurors in the box at one time, rather than go through the same rote questioning juror after juror. Ultimately, I think we have to ask, who is the jury selection system for? Certainly it is for the parties. The parties are entitled to a fair and impartial juror. I think we can achieve that with panel voir dire. We also have to consider the interests of the other participants in the system. Jurors have an interest in the system. A panel voir dire system takes less time and is less stressful to them. And I think taxpayers have an interest, too, in seeing that justice is done as efficiently and with as little taxpayer money as possible. So I know we're going to hear a variety of views here, but that's the position that Justice Borden and I in a forthcoming article have taken. Mike, thank you very much.
Thanks, Judge. Next is Kevin Kane, our Chief State's Attorney.
I haven't written anything, I don't think.
It's a spirit.
I'll try, though. Thanks, Mike. Thanks to everybody who's here for this topic. It is interesting. The title of this panel is, Do We Question Too Much? The answer is simple and obvious, I think, at least to me, although I may be wrong, but I shouldn't say I may be wrong. The answer is obvious, we do. Absolutely we do. We question way too much. I like the individual voir dire. I would hate to do without it. But unless we learn to restrict our questioning and be more responsible in the way we take advantage of that privilege, and it is just a statutory privilege, it's not a constitutional right, unless we learn how to take advantage of that properly and exercise it responsibility, we can lose it and we should lose it. Because we're wasting a terrific amount of time selecting juries. We're wasting resources, we're wasting jurors' time, we're wasting court time, and we're driving up the expense of trying cases, and that is one of several factors that is causing us to try a lot fewer cases than we should be trying, because it just takes way too long, and jury selection is one of those things. Now, I said I like jury selection. One of the things I worry about is there are unintended consequences for everything, and sometimes things fit together. One of the things that helps us, in a way, having jury selection that takes a while, is time to prepare a case or time to get evidence tested at the forensic lab. There's a huge backlog at the forensic lab, whether anybody knows it or not. More and more samples are collected by police that have to be processed for DNA. Defense attorneys want everything collected, examined. We, prosecutors, tend to be more selective in what we ask to be tested because we don't want to waste the resources. But the reality is when you go to trial, more likely than not, you ought to test everything. The lab can't do that in the normal course, and their backlog is about 2 years. What's happening now is we get cases, the judges are naturally pushing us, get this case tried, we've got to try this case, it's been on the docket too long, okay, it's up for jury selection. It's surprising how many times we think, thank God we have a voir dire here, the lab's going to have 2 weeks to test this evidence. Because the reality is, without trying to delay it on our part, It's going to take 2 weeks with most defense attorneys, because most defense attorneys and some prosecutors ask way too many questions. So I hope if we ever do get rid of or shorten voir dire, the lab gets enough facilities, enough of a staff to test the evidence so we can try cases fairly. You have to think about that. The panel of voir dire, it's not a constitutional right. Judge Schuman made that clear. The Constitution was amended in 72. There was a period of time between 72 and 1977 when that statute was enacted, in which several judges, and I remember being in Middletown with Judge Kinney for one, and there were several others, used panel voir dire. It worked well, and it worked well, it moved fast. In those days, jury panels came in and they sat for 4 weeks. A prosecutor had a terrific advantage at that because he got to know the panel pretty quickly and knew pretty quickly those jurors that he or she didn't want to pick. Defense attorneys may not have had that advantage because they weren't in court every day like the prosecutors were. We could pick jurors very fast. Even after getting to know the jurors, I'd often say to defense attorneys, I'd give them a list and scratch out a few names. You can have any one of these jurors you want. You don't need to take a long time. Our purposes for questioning jurors are twofold. One is to enable a court to determine whether or not the juror should be excused for cause, for bias or prejudice or whatever. Two is enabling a defense attorney or prosecutor or a civil attorney to decide whether or not to exercise a peremptory challenge. Now, we have a lot of peremptory challenges. I forget the number. It's been too long since I've tried cases. I think it's 15 on a felony and 8 on a misdemeanor. Am I right about that? I don't remember. 8 on a felony, my memory, and maybe it's 15 on a
4, 6,
on capital.
4 on a misdemeanor.
Anyway, there's a number of peremptory challenges we get which are pretty good given a panel to select. Some people think not too many. Maybe we'd like to have more, but there has to be some limits or it'll go. So those are the two purposes. Now, it's very hard for a trial judge. There are certain purposes for which questioning is not proper. It's not proper to gauge how a prospective juror will react to evidence that you anticipate might be introduced at trial. It's not proper to ask questions for that. It's not proper to ask questions to try to curry favor or schmooze the jurors or get them to like you or whatever. We can't resist doing that, though. We're human beings. Some people have a harder time resisting it than others, but that's kind of a natural impulse we do, and that's one of the things that causes us to ask too many questions. There's other times when lawyers will go on and on asking questions, and I'll sit there and think, my God, what the heck, how is any answer to that question going to affect this lawyer's decision whether or not to exercise a challenge? And because of a variety of reasons, one, I don't think we try enough cases now, so we don't have enough experienced trial lawyers, and a lot of inexperienced lawyers some of them are thankfully a little bit nervous and don't ask too many questions because of that. Others aren't nervous, but will go on and on and on asking questions, and you think, my God, what's the reason for this? As a prosecutor, you sit there and think, should I object? And you think, what if the judge agrees with me, sustains the objection, and then it gets overruled on appeal? I don't want to lose a conviction because of an improper ruling on a voir dire question. There was a period of time in the early 80s when some judges, Judge Higgins, I remember one of them in particular, made an effort to restrict questioning on individual voir dire and would draw the line tightly between what he viewed permissible and impermissible questions. Is a question designed to elicit a juror's reaction to evidence that might be introduced, or is it designed to uncover whether or not that juror may be prejudiced in a particular case? It's proper to question a juror as to whether or not he or she is prejudiced for or against police officers. Is it proper to ask a question such as, how do you feel about eyewitness identification? Do you realize eyewitnesses can be mistaken? When you hear about eyewitness identification or photographic lineups, what's your reaction? That seems to me to be the kind of question that's improper. A trial judge is sitting now trying to rule on an objection that's made, and the trial judge is going to be thinking, if I sustain this objection to that question, is the case going to get reversed on appeal? And you don't want to see that happen. So it's very hard for judges to restrict questioning. if some argument later on could be that this question was designed to elicit a possibility of prejudice. And I think we've really abused the voir dire. We've abused it greatly. We've caused way too much delay, and I think we're going to lose it if we're not careful, because while the practitioners, I think, like it, the legislature is very conscious of the expense and the waste of time. Jurors who go through the process sometimes don't like it and complain vocally, and victims who sit there and watch trials and watch the delay become concerned. So we've got to find ways to address this in a practical manner, and discussions like this are very good.
Another former prosecutor, Judge Linda Lager.
Good afternoon. I'm very pleased to be here. Many of you may know that I was a co-chair of the Public Service and Trust Commission's jury committee, which spent approximately 10 months looking at the life cycle of a juror from the summoning through the trial. And I actually have two members of my committee here, Rick Silver and Judge Schuman, both served on that commission. Judge Devlin, who's on the next panel, also served on that committee. And if you ever want really interesting reading, I would recommend the report. It's a we issued a very detailed report, and it's available on the Judicial Branch's website. The committee made 36 recommendations, and what I want to talk to you a little bit about this afternoon are two of those recommendations that came out of the subcommittee devoted to voir dire, which Judge Schuman sat on. And the first recommendation I want to talk to you about is the jury committee's recommendation that optional voluntary panel voir dire be made available to parties in both civil and criminal cases. But before I get to the specifics first of the recommendation, and more importantly explain the process to you, I think it's important for us, for the purposes of this discussion this afternoon, to define what we mean by the term panel voir dire. Panel voir dire, or panel jury selection, means many different things in many different jurisdictions, and what I want to clarify is what Connecticut offers and has in fact offered since 2004 with respect to civil cases as a voluntary panel jury selection option. And so the history is that the Civil Commission, which has been in existence for many years, was looking at the problems that are specific to civil jury selection, particularly, as you could see from Judge Schuman's statistics, the length of time on average that it takes to select a jury, or has taken to select a jury in a civil case. And noticing that there were certain categories of cases, particularly rear-ender car accident cases and motor vehicle car accident cases and intersection accidents and so forth, in which the jury selection was actually taking far longer than the entire trial, opening, evidence, closing, charge, and jury deliberations. And people were concerned about whether that was in fact acting as a disincentive to the parties opting for a jury trial in civil cases. That was brought up in the Civil Commission, and the Civil Commission formed a working group, and that working group made a recommendation to the Commission as a whole, and that recommendation was for voluntary panel jury selection in civil cases, and that was first presented to the CBA annual meeting at the Litigation Section Committee's meeting in 2004 and has been available as an option in civil cases since 2004. And the jury committee has just recommended that that option be expanded and be available in criminal cases as well. And here is essentially how it works. And I want you to note that it is very different from many people's ideas of panel or group jury selection that they've gotten from either practicing in another jurisdiction or from selecting juries in federal court here in Connecticut or elsewhere. First of all, it's completely voluntary and requires the consent of all the sides to the case. Second, what the parties are waiving is their statutory right to sequestered individual voir dire, but not their right to individually question the jurors who form the panel. The first step of our voluntary panel jury selection in every case is for the judge to conduct a pre-screening of the panel or of the group that comes down for biases and conflicts and other grounds that would amount to a challenge for cause. These questions that a judge poses in the pre-screening are questions that would most likely be asked by the lawyers of every veneer person when they came in individually. For example, have you ever had a very positive or negative experience with the judicial system? Have you made any claims if it's a civil case? Have you suffered an injury similar to the one on trial? And the sort of standard, do you know or recognize anyone, have a conflict with the schedule for the trial, and the like. In the way that it's done in the state court, that is done by the judge, and it's done individually with the panel members who indicate they have an affirmative answer to the list of questions that the judge has already reviewed with the lawyers in the case and then posed to all of the members of the panel. And that part of the process is a sequestered process. In other words, those individuals who give an affirmative response to this list of questions are brought in and interviewed by the judge outside of the presence of the others. That goes a long way to alleviate the concerns that the panel will be contaminated by somebody blurting something out in front of the other people. The judge can and should and usually does ask open-ended questions to probe for bias, and the counsel can request the judge to excuse a juror if the judge has concluded that the answers are insufficient to form a ground for cause. The goal of all of this first stage pre-screening is to obtain 16 relatively conflict-free potential jurors who then get seated in the box. That leads us to the second stage of Connecticut's voluntary panel jury selection option. The jurors are seated in the box. Counsel are given a seating chart. Counsel have time before they question to review the individual confidential juror questionnaires that the jurors have completed, as well as to think about the answers that some of those jurors may have given to the judge's questions. Obviously, not everyone in a group is going to indicate a problem at the pre-screening stage, but there is some preliminary information counsel have available. Once those jurors are in the box, counsel can go about the questioning in almost any way they choose. There's an enormous amount of latitude that Connecticut judges give at this stage of individual questioning. If a lawyer wants to individually ask a question of each of those 16 people, the lawyer can do it. If a lawyer wants to ask one juror to respond to an answer of another juror, the lawyer can do it. If a lawyer wants to ask the jurors to respond to certain questions by a show of hands, the lawyer can do it. It's very, very open-ended, and we are also extremely flexible in the routine of it. And counsel can kind of agree, how do they want to do this? Plaintiff or prosecution start for 20 or 30 minutes, switch to the other side, follow up. You choose. Ultimately, everybody exhausts their questions. There's only so many questions you can ask, and we're done. The third step is the exercise of the peremptory challenge. Again, the lawyers are given some time to consider the answers that were given, to collect their thoughts about how, the observations they've made of the jurors as they sit together in the box, and we use a strike system. This is really unusual in Connecticut jury selection practice because in the sequestered individual voir dire, as you know, those of you who practice it, you have to exercise a challenge. You either have to accept or exercise a challenge at the conclusion of all sides questioning of each veneer person. So as was already pointed out by, I think, Kevin Kane and Judge Schuman, you don't always know who's coming next. And you often, if you're a wise lawyer, you will leave a peremptory challenge in your back pocket. And if you only have 4, which is what you get in a civil case or a misdemeanor case, that's 25% of your peremptories that you have to leave in your back pocket, and it gets to be a little tricky. So That's how it works. Let me describe very briefly what I believe are the benefits of this process, particularly in civil cases, because as some of you may know, jury selection in many of Connecticut's civil cases does not occur with a judicial presence. With panel jury selection, the judge is always present throughout the entire process, and so it's presided over by a judge, it's on the record, and it's dignified. Judicial pre-screening of panel members by the allows a probing for bias and for other grounds of cause, and counsel can have a say in whether the prospective juror makes it to the panel. And after pre-screening, the judge is not involved, which is very, very different from judicially directed voir dire, which has been subject to a great deal of criticism in other jurisdictions. There are no restrictions on the questions that counsel can ask of the jurors. There is a meaningful exercise of the peremptory challenge. You get to see, as counsel, how the jurors interact with each other, which is, by the way, what they have to do when they serve on a jury. And I think if you have the skill set to observe what people do as well as what they say, that you get an enormous advantage by using this form of jury selection. A lawyer once said to me that one of the benefits of panel jury selection is that you know your 8 jurors are embedded in that group of 16 if you're picking in a civil case, and you are looking to put that group together, and you actually literally have that in front of you. Now, I want to acknowledge that panel jury selection is not appropriate for every case. But I do think that more extensive judicial pre-screening prior to sequestered individual voir dire, which is another recommendation of the jury committee, is appropriate. In my experience, and I have pre-screened in almost every civil jury trial I've presided over for the last 10 or 12 years, from the garden variety rear-ender to medical malpractice cases, to employment cases, to wrongful death cases. That process has not only allowed the jurors to feel more comfortable discussing sensitive issues with me before the lawyers, such as the death or serious injury to someone close to them, or negative or positive, extremely positive views of the court system, and it really has led jurors to express things which established, in my opinion, the opinion of the counsel, that juror does have a conflicting bias. But also, the jurors appreciate that a judge is involved in that process, and in fact are more candid because a judge is involved, because of the dignity of the robe and the open court proceedings. Counsel have also responded quite favorably because, as a practical matter, the hour that I may spend on the bench pre-screening leaves them with more relatively conflict-free jurors, and it enhances and increases the efficiency of their sequestered individual voir dire, and that's true no matter whether the case is simple or complicated. So there are enormous benefits of, I think, having judicial pre-screening in all of our cases, which was a recommendation of the jury committee, in which the judicial branch is in the process of implementing. That, by the way, does not require a fixed number of jurors on a panel. There's been some discussion here about the cost saving of panel jury selection. I haven't seen Judge Schuman and Judge Borden's statistics. But one thing that you have to keep in mind is, in order to do panel jury selection, we need minimally 32 veneer people brought to the courtroom so that you can get the panel of 16, because you really have to appreciate that people are going to have scheduling conflicts or know somebody, or have other issues that just are going to prohibit them from being able to serve in that case. And if we want to do it right, we found that 32 is the minimum to make it work. There are some things that have been brought up in Kevin's comments. He talked about the fact that there's far too much questioning, and in my experience, I've been on the bench now 19 years, and I've sat civil and criminal. I think many lawyers are not effective in the way in which they conduct the sequestered individual voir dire. They squander what, in my opinion, is an amazing opportunity to ask people in front of them open-ended questions and learn something about those people's lives and their past experiences, which will inform what those people do when they get together in the jury deliberating room. And instead, they give speeches or they ask leading questions, or they do both, and they think that because their gut tells them in the first minute or so that that's a good juror, that they have the rest of the time to do that, but I'm not so sure the gut is always right. I have sat in civil cases where there's been sequestered individual voir dire. The jury comes in on the first day, and I've looked over to the lawyers and seen these astonished looks. Oh my God, did we actually pick those 8 people? 7 women and 1 man, for example, whatever, I've seen it. I want to say that I think that the judicial branch has been very positively in favor of promoting options for jury selection in Connecticut cases, and that the branch is not in favor of eliminating the sequestered individual voir dire, and I think there are good reasons for that because it clearly has a role in certain cases. But I would hope that with better education and training, both for the bench and the bar, about how to go through the panel jury selection process properly, we'd see more people electing that, and as a result, we'd create greater efficiencies and perhaps even see more jury trials, both on the civil side and on the criminal side.
Thanks, Judge. And Judge Lawlor mentioned the potential reading assignment. We're in a law school, right? People do homework assignments. And I just want to mention that for the people watching at home on CTN, if you go, there's a website that has these reading materials on it, right? And I found it by Googling Juries and Justice Quinnipiac, and I got there. But if you go there, you'll see the biographies of our panel members and a series of readings, including a couple of recent articles by our next speaker, Attorney Norm Pattis, who reaches out through the popular press to try and raise these issues among citizens. And I think he had some very compelling arguments just last year, especially in the context of some unfolding jury selection that was taking place in some very public cases, about whether or not we should reconsider this policy. So, Attorney Norm Pattis.
Thanks. I should begin by saying I find myself extremely uncomfortable agreeing with 2 judges and the state's top prosecutor, and wonder whether I ought simply to walk out the door now. But I bring a perspective of a small firm, primarily criminal defense, federal civil rights practitioner to this issue, and I am begging for legislative change in the form of making it a rebuttable presumption in favor of panel voir dire. I'm not saying that it is appropriate in every case, but I've tried 100+ cases. I lost track a while ago. I can only think of 3 or 4 where I felt that individual sequestered voir dire was necessary because the issues were so sensitive. In the broad range of cases, jury selection is, quite frankly, the crown jewel of our democratic process, and I was encouraged to hear Jeff Myers read Jefferson's remark. It's the one place where we ask strangers to come together and put to the test Cicero's definition of a republic. A republic, he told us several millennia ago, wasn't just any collection of people. It was a group of people bound together by common interests, but more importantly, a common conception of right. We ask people to come together and test the legitimacy of theories that the state brings. Are they correct? Sometimes creative lawyers ask juries to disregard the law. We're not here to talk about nullification. But the point is that jury selection is a revolutionary act. It is one of the few times in the criminal context where you can say to a group of jurors, my government, your government, our government got it wrong, we believe. We'd like to show you why. Can you listen to that case? And that's what jury selection is. It's empathic listening. I agree with Judge Lawlor. Far too many lawyers give speeches. I don't try a lot of civil cases in the state court. My civil practice is confined largely to federal court. I wandered into a state court civil jury selection without a judge on the bench in December, and I was stunned by what I saw. Speeches, long-winded pontification by a man who I admire, my adversary, and I would object from time to time and bring the judge down, and eventually the process was brought under control. The most important tool for a jury selection, you have two of them, and if both of them work, you're a lucky guy. It's listening. I don't know that judges lend dignity to the process. I think they often get in the way. I frankly don't prefer the federal God-in-the-box system where Moses from on high intones the question that everybody's afraid to say no to. You can be fair, can't you? You know, just because this guy is alleged to have taken money from the bank, you don't think he's guilty, do you? I mean, these aren't questions. That's an intonation designed to fill in a federal checklist, and it tells us absolutely nothing. But I do believe that group voir dire can serve the interest of justice, because what you do is you get jurors to speak to one another. I don't know how many of you have ever been on jury service. I've not. I had the misfortune last year of probably spending 7 to 8 weeks in individual sequestered voir dire in a series of cases. I was mind-numbed by the end. I look at these poor jurors sitting up there with every eye stared at them, more or less how I feel right now, but I do this for a living. But everybody's staring at them, breathing on their next question. What do you think about this? What do you think about that? What do you think about this? What do you think about that? And the person answers as best as they can, or as best they're permitted to do so. Consider the difference, however, when people reason together. I once had a case in federal court where a judge permitted me to conduct my voir dire. I laid out the worst facts about my client and that I thought were going to be admissible. And I said, this is what you'll hear in this case. It's a case where he had sued some prison guards for beating him up. And this is what you'll hear. How many of you believe that you can be fair and impartial in a case involving a man like this? 9 of them raised their hand. The judge called me up to the bench. Norm, we're going to get rid of these people. They can't be fair. I said, look, if I need help picking the jury, I'll ask you. Let them be. And then I asked them to talk to one another some more, and I asked them to engage other members in the group. And what evolved was a sense of who could sit and who couldn't. And the hostile jurors drew out the others and created a division that made it quite clear how I could use my peremptory challenges. Now, could I have done the same work on an individual basis? Absolutely. But instead of taking 3 or 4 hours, it would have taken 3 or 4 days. And from the perspective of small practitioners, we are getting killed in a bad economy on costly delays. The principal problem that brings lawyers before a grievance committee is communication. What am I supposed to tell a client when I wait 3 or 4 days, or years rather, for a trial? I file a complaint, we conduct some discovery, and then the case lingers there ad infinitum. And the client calls every 6 months or so wanting to know what's up. What am I supposed to say? We're waiting. We filed our jury claim slip. I'll write to you before you die if you're lucky. I mean, these delays are killing the practice of law. They are making it hard on lawyers. They're making it, group voir dire also adds the expense of the time you must take. There aren't many GA trials, the low-level criminal court cases anymore, because no one can afford. I heard a lawyer say to one of my associates the other day, he doesn't try cases in the GA. He brings the cases in and he pleads them all out. If they need a trial, he refers them elsewhere. Do you think the interests of justice are served by that lawyer's representation when the prosecution knows full well that he's not taking the case to the mat, that he's going to deal it out if the client can't afford to hire a trial lawyer, much less whether a judge will let you out if you buy a bad case that you can't try? So I think the cost. It imposes cost on little people that they can't bear. It imposes delay on everybody. There is no argument that I'm aware of in favor of the efficacy of individual sequestered voir dire. 49 other states don't do it. The federal courts don't do it. Is anybody in this room going to stand up and say that Connecticut justice is superior to that administered anywhere else in the world? If so, I got a bridge. Okay, well, come see me in the end because I've got this investment program for you. There's a piece of the Brooklyn Bridge with your name on it, but all I need is $29.95 and your credit card, and I'll sell it to you. So I think public respect for the court system would also increase if the docket moved more quickly. Jurors are often puzzled, especially in the criminal case. You walk in, the alleged crime happened 4 years ago. I've heard from jurors afterwards that one of the most troubling factors for them is the delay between the institution of the proceeding and the trial. Now, I have a confession to make. I am ambivalent about this because as a criminal defense lawyer, my job is to force error. I mean, let's face it. I don't have Kevin's duty to do justice. I have a duty of candor toward the tribunal. I have a duty of zealous advocacy. And if that means waiting, and forcing delay, hopefully that a witness dies of natural causes. You have to give that. I once said to a client, he said, what's my best best defense. I said, your best defense is if the witness disappears. He says, how do I do that? I said, you don't. Sometimes you let nature run its course. But we don't do that here. It's never a good thing, never an acceptable tactic. So, I have some delays. It works there. And the conduct of voir dire with a judge who may not be confident gives you ample opportunity to try to force errors, scooch the boundaries, get under their skin a little bit, ask that question once, have it objected to, change one word, ask it again, and before you know it, perhaps the judge is pushing back too hard, and voila, you've got the ace in the hole that is necessary in every criminal case, adequate grounds for appeal. Those are reasons that others, not me, might want to get rid of individual sequestered voir dire. I think that commenting on the presentations that have thus far taken place, I disagree with Judge Schuman. I don't think the statute should be amended to require panel voir dire. I think there are cases where individual voir dire is necessary, so I've said it before, I'll say it again. Let it be a rebuttable presumption. If a case is so extraordinary, and the two cases that class of cases I think of are murder or sexual abuse of children or capital cases, I think individual sequestered voir dire may be necessary in cases like that. But you should be required to make some affirmative showing that a group process won't work. I was startled to hear Mr. Kane, who I love and admire, say that the state does something criminal defense lawyers do too, and that is they wait to prepare their files till during jury selection. Now think of how different the world would look if you had a rocket docket and you knew that once you filed your writ, you were going to try it in 6 months. Don't you think cases would settle more quickly? Don't you think clients would be happier? Don't you think we'd spend much less on administering justice? What's more, if we knew that you couldn't prepare your case during jury selection, maybe the state wouldn't bring so many frivolous prosecutions. The criminal defense bar talks about over-criminalization. If you make everything a crime, you create statutes. The law's great fourth outfielders are interfering with a police officer, breach of peace, risk of injury. They're things that get charged when nothing else fits. We call them the fourth outfielder in our office. You didn't commit a crime, well, you certainly interfered with the officer. Maybe they would bring fewer of those prosecutions if they knew they couldn't sit on them until the guy violated the conditions of bail and they had another free and easier shot at him. As to Judge Lawler's comments, she was the person who made a believer of me in the efficacy of group voir dire in the state system. I had a police defendant in an unreasonable force case. I'd won a case against him in federal court for a good deal of money, and lo and behold, this hapless mope popped up on my radar again, and I sued him in state court, and the case wasn't removed. Judge Lawler said, why not? I'd just beaten the tail off the guy a year before in federal court, and I thought, well, I know the case. I'm reasonably confident in this area of law. It's a perfect controlled experiment. We picked that jury in 2 or 3 hours. I lost, but I don't blame the jury. It was just a worse case than the one before. Juries are a great democratic experiment and a great tool. They're an opportunity to create a sense of community and to have the community speak about the limits in the criminal context of what the state seeks to do to ordinary citizens. Why we submit to a false sense of individualism in the group voir dire process and say that we must treat each man as an island when we set them when we introduce them to one another as a group to make a decision is a mystery to me. I think the interests of justice would be served by the reform of individual voir dire. It can't happen soon enough.
Thanks, Norm. As I said earlier, I spent a long time in the legislature, and this particular issue, this question about whether or not to rewrite the existing statute on individual sequestered voir dire was always there, but in the background, sort of on the back burner, and once in a while people would suggest it, and if they did, if it looked like it was seriously going to be considered by the legislature, you'd end up talking to Rick Silver, and he would tell you what you're about to hear. So with that in mind, Attorney Rick Silver.
I could just get up there.
Go for it.
Well, I'll make an admission. I'm a trial lawyer. I'll make a second admission. I deal with individual voir dire on a very frequent basis and have done so for many, many years. And I am fortunately, based on the equal time doctrine here, I should be allowed 40 minutes. Right? But I only have 10. So based on that, I'm going to refer you to a piece that Amanda Whitman from my office and I have submitted to the Connecticut Law Tribune that's entitled Individual Voir Dire Equals Justice, and it's actually online here. Because I'm not going to be able to rebut everything that was indicated so far. Basically, it's our view that individual voir dire, although not perfect, is the best system. It's the best system to, in fact, expose bias and prejudice and a personal background that makes the juror unsuitable for the jury selection on a particular case. And I think the major point that Judge Schuman was trying to make is that individual voir dire takes additional time and that we take many hours. Here's my response to that. My response is, as a practitioner and as a trial lawyer, I do not believe that the judicial system is supplying enough jurors. I've come to court ready to try a case, ready to pick jurors all day. 11:30 in the morning, we're out of jurors, there are no more jurors. I've had day after day after day of not having any jurors available in the afternoon. That's a significant cause of delay, and it must be remedied. It must be remedied statewide, because if it's not remedied, there's going to be continual delay. Another thing that I agree absolutely with Judge Lawlor is that pre-screening is extremely important. Extremely important. And I agree with the way she proposed it. She's absolutely right. The problem is it is not done statewide. We don't have statewide pre-screening. And here's what pre-screening should be. Pre-screening should be that the attorneys submit to the judge in a case at 8:30 in the morning, not 10, not 11, not 12, 8:30 in the morning, questions that are appropriate for the case, and that the jury answers those questions, the prospective jury answers the questions. Do I know anybody? What's my background? What's my employment? Do I have a problem serving because of vacation? Do I have a problem because I don't have child care? All those issues are addressed, and the judge, after hearing all those difficulties, says, all right, I'm going to take all the people that I have a problem with, that I know is going to waste time examining them, I'm going to put those aside, and we're going to present people who can serve as a juror. And by 10 o'clock, there should be 32 jurors. I don't know whether I've ever had the experience of having 32 jurors available, by the way. I suppose once in my career it's happened. But in where I practice mostly in Stanford, we get 5 jurors, 8 jurors, and you're through them very quickly. If you have a panel of 32 jurors on the individual voir dire, you're very likely to have sufficient jurors to serve all day. Now, the counterbalance is the state has to provide funds for which to call jurors and present them. But I agree with Judge Lawlor. I think it's very, very important to have pre-screening, because I think it sets the day, it moves the case, it shortens immensely jury selection, because you can focus on, based on the questionnaire, you can focus on the issues involved. And I will tell you this, I do not educate jurors because I don't think you can do it. I think jurors object to it. I don't think it's wise. And I think if lawyers do it, the other side objects, brings the judge out. I don't think it happens. I think it doesn't, in fact, happen. And if it does happen, then a judge should admonish counsel not to do it. Now, I disagree with Judge Schuman on one point. Judge Schuman says that the individual voir dire is very recent. Based on the Connecticut General Assembly Office of Legislative Research in 1997, in fact, did an investigation, and they found that the system, the custom of individual voir dire dates back to the 19th century. Now, I can't tell you that I was there in the 19th century, But I can tell you I've been trying cases before 1972, before 1977, and we always had the individual voir dire. And I've never had a judge, in my experience, impose a box voir dire. So I frankly disagree with the judge that it's not in our system. Now, the real testament, and Judge Lawlor describes a box voir dire, or what I call sometimes an en masse voir dire, in a different way than I've seen it done. And in 2007, Attorney Anthony Bonadies and myself were co-chairs of a demonstration of the individual voir dire and the box voir dire as a teaching purpose, and to also try to illuminate how lawyers can, in fact, effectively do a box voir dire. And I will tell you one thing, the box voir dire is very difficult, very delicate, and raises a myriad of issues. Now, if in fact, and I don't disagree with Judge Lawlor, if two lawyers, and frankly not significant cases, in fender bender cases, not medical malpractice, not where significant rights are at issue, want to agree to in fact use a box voir dire, I don't have an objection to that. However, in practice, what has been found is lawyers are not utilizing this panel voir dire system. And they're not utilizing it, I think, because it is very difficult and it doesn't give you the right results. There is no question that you can't ask yes or no questions and get real information. It's not possible. In other words, the question you have to ask, let me give you an example, in a medical malpractice case where you're dealing with a voir dire person who in fact's family has had cancer, similar to what the plaintiff is. The only way that you can truly explore the background of that is to ask questions about what family member had it, what the prognosis is, what that individual's knowledge about cancer is. And you can't do that with yes or no questions. And I will tell you, you can't do that in front of 32 other voir dire persons. You can't do it. You can't start asking personal, intimate questions with 32 people in the room. It's difficult to ask those questions in a conference, not in a conference room or in a courtroom that just has the lawyers, let alone where you have 32 people. And when the question that has to be asked is an open-ended questions. What do you think about that? What's your feeling about your spouse having cancer? What did you go through? What did she go through? Because if you don't know those facts, how do you know what that juror is going to do? And it cuts both ways, by the way. The people, the trial lawyers, all right, those are the people in the trenches, the real trial lawyers. The real trial lawyers, whether plaintiffs or defendants, want the individual voir dire. They want a fair system. They want a system that exposes bias and prejudice and that works. Now, Now, I think Judge Schuman indicated that he didn't feel that there was any research that validated essentially what I'm saying. And I would ask you to look on the website, and I want to mention two articles. One is from the Law on Human Behavior, and the other is from a court review by a Judge Mize. And as a matter of fact, Judge Schuman quoted Judge Mize in another instance. By and large, literature supports that bias is best elicited by use of the individual voir dire, not the panel. And I want to quote from the article in Law on Human Behavior. Bias of potential jurors is best discerned when the voir dire persons are examined while individually sequestered. Additionally, Judge Meyer said, individual voir dire resulted in discovery of jury bias warranting being excused for cause which has been missed during group voir dire. Judge Myers further said, individual voir dire of potential jurors resulted in complete and candid responses than voir dire in the open courtroom. He went on further to say, the en masse voir dire can introduce material that can affect the whole panel, requiring dismissal of the entire panel. And that is not theoretical. In fact, that's what happens. Somebody blurts out all those frivolous cases. There are all these frivolous lawsuits. There's no control over malpractice. My doctor is sued. My obstetrician had to leave Connecticut because of being sued. What do you think that does to a panel? That infects the whole panel. And those comments are not rare, by the way. Those are not rare because I hear them all the time on individual voir dire, all the time. And listen, I'm delighted to hear them. I'm delighted to hear those comments because, number one, they don't affect the other panel. A voir dire person is telling me the truth, is really indicating what they really feel, and that's what we have to know, and that's good, and it's good because, in fact, it removes that person from the jury. Now, I've already talked about the lack of sufficient jurors, and I really hope, based on what Judge Lawlor said, this is going to change. This must change. We can't have the statistics that Judge Schuman has. We can't continue with those statistics, and we won't if we have enough jurors, and if those jurors are present and are willing to serve. And the pre-screening process that Judge Lawlor described is terrific, and I'm waiting for the day that it's statewide. I'm waiting for the day that it's statewide because if it happens, we're going to cut down the length of jury selection enormously. Now, one of Judge Schuman's really main points is, how could Connecticut be the only state in the union that has individual voir dire? Well, I'm proud of Yankee independence. I'm proud of it. I'm proud that Connecticut is the only state in the union that has it because it means that we have fairness. And I will tell you this, when I meet and deal with lawyers throughout the country, trial lawyers throughout the country, how envious they are that we have a fair jury in Connecticut, that we can expose bias and prejudice. And we've been dealing with it for over 100 years, and I think it's a terrific system. And I think also that, in fact, I wouldn't trade it for $1 million. Right? If it costs $1 million for the whole state of Connecticut, I wouldn't sell the public down the river for $1 million. If, in fact, the potential time saved by abandoning the constitutionality and the statutorily protected rights of an individual in voir dire cannot justify the likely prejudice of allowing jurors and bias and prejudice to sit on a jury, it's not worth $1 million. By the way, I don't think it's $1 million in any event, but even if it was, I think what we have in the individual voir dire is precious, and I think it should be maintained. And I welcome Judge Lawler's suggestions. We get more jurors ready to serve. We in fact, examine all day, and we pre-screen, and I think it'd make a tremendous difference. Thank you.
Thank you, Rick. And we have time for a few questions. I'd like to point out one thing that didn't come up, though, which I thought I'd hear about, is the rules change as the times change. And recently we've had the advent of people, courtroom observers, using their Twitter accounts to recount what's taking place during the jury selection process. And these very, very personal questions you hear if you watch this unfold in a courtroom, being asked of these potential jurors, these ordinary citizens have been summoned into court. And I just wanted to ask that question first, and anyone else has a question. Do any of you have a reaction to this, what is likely to become more commonplace over time, this process where this often very private thing in the past is now becoming a very public spectacle, the questions and answers being asked in courtrooms?
Yeah, I think Twitter is an unmitigated disaster, and I think the Hayes trial recently in New Haven illustrates that. There's the study of social behavior is called sociometry, and a good social psychologist could take a look at the room and see what sort of energy is dynamic or generated by the attention that people focus on one thing or another. And I think when you've got a guy on trial for his life and you've got the press sitting in the courtroom having a sensitivity fest, each struggling to get a Pulitzer Prize to see who can be most sympathetic to the victim, staring at the alleged victim and twittering his every movement. He touched his head. He mopped his brow. He sighed at testimony. I think it was Twitter should be banned from the courtroom altogether. It injects something into the courtroom that does infect jurors in a way that does not find its way onto the cold record.
Well, I mean, that may or may not be true, but I think in the context of people being summoned into the courthouse, subjected to the individual voir dire, if what the questions and answers are being broadcast, it's not the trial itself even.
May I respond?
Yes.
I am not aware of any case in which any judge in the state of Connecticut has allowed twittering during jury selection. There's a big difference between allowing that happening at the jury selection time and later in a trial, and that's within the judge's discretion. But I also want to rebut just a couple of things that Mr. Silver said, because I think it's really quite important. And I appreciate that he agrees with me so much on the pre-screening, which we are, in fact, implementing statewide. But there are adequate numbers of jurors available in our judicial districts to meet the trial needs in each judicial district. I went on a road trip this fall with our jury administrator, Kay Barris, and as a result of the jury committee's work, we've actually come up with individualized plans for summoning and jury utilization for each of our judicial districts. What I want to suggest is one of the reasons Mr. Silver may be seeing small numbers of panels in his cases is that the jury clerks are aware that he conducts such a thorough and lengthy questioning of the jurors in his cases that if he had more than 5 or 8 people, we might have people sitting at 4:30 who have not been reached. The fact, however, that those people have not been pre-screened is what leads to him going through them by 11:30. And so if we could meld the pre-screening uniformly and statewide with providing an adequate number of jurors to be questioned based on the nature of the case, and judges and experienced lawyers typically know that in a medical malpractice case with a relatively conflict-free veneer person and competent counsel, and if you have multiple parties, it's going to take a certain amount of time, and that time is going to be a lot longer than the time in a rear-ender. Likewise, in a capital case, it's going to take a lot more time than a possession of narcotics case. And so if we could titrate this, by working together, obviously, then I think what we are going to do is a number of things. There will be an adequate number of jurors to be questioned within the parameters of the numbers of jurors we're summoning. Jurors will not find themselves, potential jurors will not find themselves sitting in the courthouse at 4:30 in the afternoon with 3 or 4 or 6 or 10 other people having not been questioned at all and feeling frustrated by that. And we will, I think, have a wider range of our citizens who actually get to serve by putting together these techniques of pre-screening and panel numbers that represent the case on trial.
And these techniques don't require statutory change,
These
correct?
techniques don't require statutory changes. They don't require any additional funds, and we are, in fact, trying to implement them. We're in the process of doing that.
There was a,
Do I get rebuttal?
well, why don't we just,
Short rebuttal.
okay, go for the short rebuttal.
Short rebuttal. It's absolutely true that I have been presented with a major case with 4 or 5 jurors who was dispatched by 11:30. It's been a continual event of having not significant jurors, and I try cases all over the state. And if you take a survey of the trial lawyers here, I'd like to see of the trial lawyers how many of them agree have had the same experience that I've had consistently.
But what does that have to do with anything? That really begs the issue of whether, if you had 6 or 8 or 12, you could do a more efficient job of picking. I mean, you say real trial lawyers, we all want or I guess they all want, I must be a fantasy trial lawyer, individual sequestered voir dire. I can tell you many that don't. And the firms that typically want it are insurance defense lawyers who get paid during the process, and if they decide to settle it after 2 or 3 days, well, their clients none the wiser since they're not paying. Or the large firms that are adequately capitalized and can dial for millions of dollars in every trial. The routine cases, the smaller cases, people seeking ordinary justice, they don't have that kind of money to go to trial. And when I see the dark courtrooms in the GA, and I don't see cases going into trial in the GA because the private bar can't afford to do it, there's something wrong with that. And I think I have picked group voir dire in the federal courts many, many times where I've been permitted to ask questions. There's no question in my mind that those jurors are as capable and as qualified as those selected on an individual basis. You're a master of voir dire, I've heard. I've not had the privilege to see you work, but you know as well as any experienced lawyer does that listening is what makes voir dire. Jurors will listen to one another if you give them a chance to speak, and they will educate you as much as anything. So I believe real lawyers want group voir dire. The Connecticut Bar Association is teeing up for a titanic struggle with the Connecticut Trials Lawyers Association. The Bar Association has a group that's studying group voir dire. The trial lawyers will fight it. The public will be entertained while we feed on one another.
At least one question. Let's go.
I have more of a statement than a question. Good afternoon, Your Honors and fellow members. I picked juries with a number of you and with both Judge Schuman and Judge Lawlor. I have to second what Attorney Silver said. And yes, Mr. Pattis, I am a direct defense lawyer. But I don't support the individual voir dire system so that I can pad my bill. And I would take umbrage at any suggestion that myself or any defense lawyer does that. I like the individual voir dire system because it allows me to ferret out bias and prejudice in a way that I don't think can be done, candidly, in the box voir dire system. I try mostly medical malpractice cases. So I find that I need the time to make sure that the people aren't harboring some sort of bias for or against my client or the plaintiff. Attorney Silver and I are routinely on opposite sides of the V. We're always on opposite sides of the V. But we agree in this respect. I don't think that any good lawyer should make a judgment within 1 minute as to whether or not a potential juror is right for his or her panel. And certainly I don't, and I know Attorney Silver doesn't. In fact, I think there is a common experience among all of us that questioning for a period of minutes, some question for an hour, sometimes reveals by the end that there's something that the potential veneer person didn't tell you. They didn't tell you in response to the pre-screening. They didn't tell you in response to the warm-up questions that we all ask to get them comfortable. They only feel comfortable revealing it after they've sat for a while. We all have anecdotes. I had a famous person who was a TV personality, sat through the entire voir dire, plaintiff, co-defendant and defendant, stoic. I can be fair, I can be impartial. When the plaintiff's lawyer began to ask about rendering fair, just, and reasonable damages, he started to cry. His wife had been in the hospital for 8 weeks, suffering from cancer. He didn't want to reveal it to us. He was this close to being picked on a case where I was defending a doctor who'd been alleged to have misdiagnosed cancer. And but for the tears running down his face, we never would have known. We certainly would not have found that out in voir dire.
How do you not know that? How do you know that if he'd sat there with a group and his conscience had preyed upon him during that same time while he listened to other jurors tell stories about losses of their own? Perhaps he would have been ennobled or felt less shame and would have decided that others are just like me and there's no reason that I need to feel intimidated.
Perhaps, except I don't care to speculate. I know what happened in
the other 49 states that are doing it this way, I don't hear complaints from them that there's no justice. I don't see revolution in the street. Connecticut, we have our Yankee independence. That's probably good when you're out buying candles for the holiday season. But that's not good enough for me.
I don't see anyone from California here or Idaho here, so there's
Did you expect to?
There's no
Did
form
you
for
expect
them
to?
There's no form for
Did
them
you
to
seriously
complain.
expect to see somebody from
No,
California here?
Time
out.
They are here.
Flag on the plate. Okay.
The
Got the
bottom line
statement.
is, when presented with the opportunity, and Judge Lawlor has done this for me and my clients, to pick in with the box, and when the judge says, Attorney Stockman, go back and ask your client, I do. They tell me, it doesn't matter what the cost is. We want your judgment. We want you to hear from the people and make an assessment, a learned assessment, as to whether or not they are the kind of person that should sit on our jury. That's why.
But you have allowed pre-screening.
Oh, I
And you
agree.
like pre-screening.
I think the pre-screening is essential, and I don't agree, Your Honor, that it's done in every courthouse. It isn't.
No, we're trying to implement it in
Okay.
every
But we have
courthouse.
had, and I've had experiences with Sean and with Rick, where we generate a questionnaire among ourselves, run it by the judge. That questionnaire is given to the potential jury members, and it eliminates anybody who really has a significant issue that they want to reveal up front. Then the additional questioning will help us to flesh out whether or not there's something that they're hiding or harboring.
It is, however, very likely that if a judge is presiding over a pre-screening process in which, let's use your case as an example, the question is posed, have you or anyone close to you had a cancer in the family? And would that impact your serving on the jury, that your person who you had already spent approximately, an hour questioning, maybe longer, would have answered that question to the judge, sequestered from the others, and would have been gone before the individual questioning by counsel began. Wouldn't that have been a blessing for him?
Absolutely, for everybody involved, because it's uncomfortable when someone suddenly starts to cry and you realize they're suffering a tragedy as well.
Okay, we just had the 2-minute warning, so one question, go ahead.
Yeah, I'd like to ask the panel to consider the, first of all...
Could you state your name, please?
Tim Moynihan, Attorney Tim Moynihan, actually on the next panel. But I think that if we restrict this to the law and the law system in place, looking for alternatives, we may be missing something. The pre-screening is a great idea. I agree that it's necessary. I can't imagine anybody not agreeing that pre-screening would expedite things and be fair. But let's think about what happens when we are selecting someone for a position that's important to us in our offices or in law schools. When Dean Saxton was interviewed for the job, did they bring in 6 or 8 or 10 and question the panel together? When the 2 judges on the panel were interviewed by a committee in the state of Connecticut to see whether or not they should be chosen over the other candidates to become the judge, did they bring 10 or 12 or 15 candidates in and ask them to share their personal experiences and bring the truth out of the intermix of feelings and emotions and life experiences?
But Tim, the problem with that argument is they weren't being asked to do group jobs. Would you pick an NFL team by getting 11 guys and not asking to seeing how they interacted or seeing how their skills complemented one another or whether they could get together and act as a team? Would you do that?
I think, for example, when I pick an office administrator,
That's a sole job. She's not doing
it's
a
a
group
sole job interacting with other people to make the whole real and true and efficient.
Wouldn't you
and
want to
right.
see her interact with those that she's going to perform her work with?
I think that when you talk to somebody and you're going to hire them for something important, you expect them to interact with other people. You don't expect them to be just a leader. When we're picking juries, we look to see who we want to be the foreman. And
what better way to see that than to see them in the context of a group?
I've just explained to you. I think anytime you're making an important decision, you do it because you want to interact one-on-one, and you make that decision. The other thing I think you lose, and I think any experienced lawyer is very sensitive to his preemptory challenges. And he doesn't want to use a preemptory because he's got to harbor those very carefully and keep them close to himself so that when you have a chance to individually voir dire, you've got a much better chance of pursuing that potential juror to see what is really might be affecting what might affect the juror's decision in the context of the trial, and eliminate a juror for cause rather than exercising a peremptory.
Okay, that's it, we're done. I apologize. And, but I want to say one thing, which is worth noting, that we're in a law school, so it's okay to have theoretical arguments, but I think there is an opportunity cost here, and I think people need to keep that in the back of their minds, that there are long delays in getting to trial for a variety of reasons. Maybe this is one of them. And sitting silently over here, my 2 former colleagues who were introduced earlier, but Gary Holder-Winfield, Representative Holder-Winfield, new Vice Chair of the Judiciary Committee, Senator Ed Meyer, a longtime member, senior member of the Judiciary Committee, they'll ultimately have to make the decision. So however you feel, you should weigh in with them today and with their colleagues going forward, because it sounds like maybe this is getting pushed a little bit closer to the front burner at the legislature. And so, and it's certainly a fascinating discussion. So thanks to all of our panelists today. I appreciate your patience.
So welcome back. My name is Sarah Russell. I teach here at Quinnipiac. And this panel is going to discuss the role of juries in sentencing decisions in criminal cases. So I won't give a long introduction of our panel because you have it in your materials. But to my right is Judge Devlin, who serves as a judge on the Connecticut Superior Court, has done that since 1993. And he was just appointed Chief Administrative Judge for Criminal Divisions, the Criminal Division of the Superior Court. To his right is Shelley Sagan, who is a partner at Zeldis, Needle, and Cooper in Bridgeport. To her right is Tim Moynihan, who is a partner at the law firm of Moynihan in Manila and Waterbury, Connecticut. And to his right is Len Boyle, who serves as Deputy Chief State's Attorney for Operations in Connecticut. So before we hear from our panelists, I wanted to say a few words by way of background on this issue. The Supreme Court has said that the Sixth Amendment requires a jury to determine if a defendant is subject to the death penalty. So in states around the country and in the federal system, juries are making those sentencing decisions in the capital context. But in non-capital cases, juries are engaged in sentencing defendants in only a handful of states. Those states include Virginia, Kentucky, Missouri, Arkansas, Texas, and Oklahoma. In most states, including here in Connecticut, judges instruct jurors that they may not consider what punishment a defendant might face if they return a guilty verdict. And in fact, even when a guilty verdict will require a mandatory minimum sentence or greatly increase the maximum sentence, juries are not informed about the sentencing consequences of a guilty verdict. So this panel will consider what role, if any, juries should play in sentencing decisions. And we'll really be discussing two related issues. First, under the current system in Connecticut, where judges impose sentences, should a jury be told when a guilty verdict will result in a mandatory minimum sentence? Should a jury know that a finding of guilt will send the defendant away for at least 20 years? Or is this sentencing information really irrelevant to a jury's decision about a defendant's guilt? And second, we'll discuss whether the system in Connecticut should be changed to allow juries to actually sentence defendants. Should juries be empowered to determine appropriate sanctions for defendants within a broad statutory range set by the legislature? Or should juries at least have a role in recommending sentences? What are the benefits and dangers of jury sentencing? Our panelists have a range of perspectives on these issues, and Judge Devlin will begin with a view from the bench.
Okay, good to see all of you. It's a pleasure to be here. So at the outset, let me say this, that while I'm not a fan of mandatory minimum sentences, I'm going to try to make the case for the status quo here. Because it seems to me, for both jurisprudential and practical reasons, our present system, which does restrict the jury's function to fact-finding, is better than either one in which they are actually the sentence served or one in which they are advised of the penalty involved for the crime that's charged in the case. And I want to focus on the second of those approaches, that is, telling the jury about mandatory minimum sentences that may be involved in the case. Now, I acknowledge that jurors have the power to act contrary to law. They do have that power. And there's historical evidence that juries have used that power. I mean, in fact, the notion that juries and, in fact, judges have taken penalty into account in rendering their decisions is nothing new. As you all know from your study of criminal law, our criminal law developed through the English common law tradition. And so it evolved incrementally. And as a result of that, the first crimes to be recognized were homicides. And actually, really all the big ideas in criminal law, actus reus, mens rea, notions about justification and excuse, all those were worked out in the context of murder cases. And then the criminal law tended to develop incrementally, so crimes like arson and rape, crimes against persons were recognized, and ultimately a whole series of crimes were recognized. The last group that was recognized in this sort of common law tradition were strict property crimes, like larceny. The problem was that although the law developed to recognize new crimes as sort of society matured, the penalty for felonies remained the same, which was the death penalty of common law. So you ultimately got to a point where, somebody who was convicted of stealing their neighbor's wagon faced the same penalty as someone convicted of premeditated murder. So in order to mitigate the harshness of the common law, juries were sometimes known to return verdicts that were clearly contrary to the evidence. And judges also sometimes thought to affect the process, either by directly telling the jury what the penalty was for the case, or judges sometimes were known to expand this idea of the benefit of clergy. At common law, if you were a member of the clergy, a legitimate member of the clergy, you could get your case transferred to an ecclesiastical court, which could not impose the death penalty. But judges, again, in order to mitigate these harsh results, would sometimes assign the benefit of clergy to people who clearly were not clergy and who probably had never seen the inside of a church. And they had all these sort of kind of phony ways in which to get people to qualify as members of the clergy. So some people have argued, and it's a principled argument, that the presence of mandatory minimum sentences in our law today, in our present penal code, creates the same harsh results that existed in common law, and therefore is it completely appropriate to act to try to mitigate that harshness. And one technique to try to do that, it's suggested, would be to tell the jury about the impact of their verdict vis-a-vis the sentence that would have to be imposed. Look, I understand that argument, and I think it will be made quite effectively by other members of the panel, but I would say, I would disagree with that, and I would say that's undesirable for a couple of reasons. And the first reason is this. A really good feature of our present system is that it is straightforward. Jurors take an oath or an affirmation, but mostly they take an oath to decide the case just based on the facts presented during the trial and the law that's given to them by the court. Then they listen to the trial, and after they hear the evidence, are asked to just answer one question, just one question. Is the defendant guilty? They say yes, they say no, but once they answer that question, that's it. That's the end of their role in the case. And that decision is not influenced by sympathy for the victim or for the accused or for people's families. It's not influenced by what the potential punishment might be. It's only influenced by whether or not the prosecution has proved this case beyond a reasonable doubt. One question, one sort of consideration that they have to make, has the case been proven or not? Now, judges also take an oath. They take an oath to uphold the law, and we are bound to instruct juries so as not to condone or to encourage jury nullification. And these responsibilities are clear in our present law, and they're rooted in the oaths that both judges and jurors take. And they're also rooted in this basic notion of the rule of law. Inviting nullification tends to introduce sort of an element of prevarication with respect to these oaths, which I think is probably better avoided. The second reason why I think the present system is superior to these alternatives is that if the judge does tell the jury what the mandatory is in a case, what do you tell the jury to do with that? I mean, it's really not relevant to the person's factual guilt. Whether or not they face 5 years in jail does not make one bit of difference, make it more probable or less probable that they did the crime. It's an irrelevant fact, in my view. But what does it do? I mean, do we just put it into the case with sort of a wink? Do we let the lawyers argue it in their summations to the jury? I mean, how do we handle this? And the point is, in my view, telling the jury about a mandatory minimum penalty only invites jury nullification. There's no other legitimate reason to put that evidence into the case. And so if the jury, through the court's instructions, is seen as encouraging, or the jury is seen as being encouraged to engage in nullification, either based on the perceived harshness of the result or for whatever other reason, I mean, the thing is, how do you control for other applications of nullification, which may not have such a noble purpose? Look, if you look at the history of American law, you can see examples of juries acting toward a greater justice in the face of a harsh law. I understand that. But if you look at our history, you can also see plenty of examples, like in the 1960s, where civil rights activists were crime victims, murders, lynchings, and juries in the South refused to convict. They just refused to convict those people. And why? Because of racial animus, that's why. So this jury nullification can be a double-edged sword and doesn't always work toward justice. The third and final point I make is this. If you modify our system and you feel jurisprudentially it's appropriate to modify our system so that judges can advise juries of minimum penalties, for example, either expressly or impliedly, how can there be meaningful appellate review of those trials? I mean, a fundamental tenet of our law is that the jury is expected to follow the judge's instructions. But if the judge is giving the jury a green light to do whatever the heck they want in that jury room, I mean, how do you review that? Really, how does an appellate court review that to see if the person really did get a fair trial or not? So, look, like I said, I'm not in favor of mandatory minimum sentences. I think it undermines a judge's ability to really achieve individualized justice in an individual case and take into consideration all the particulars of that person. But having said that, I think that introducing these notions of having the jury as sentencer or advising them of the penalty does not advance the cause of justice. So thanks a lot for your attention.
We'll hear now from Tim Moynihan, who has actually been litigating a case where he's trying to get the court to instruct on what the mandatory minimum is in the case.
Yes, thank you. That case, by the way, is over, but this is such a big subject that I think I've got to be very careful not to go too many places and try to focus on the question of should a jury be instructed in the case where there's a mandatory minimum sentence, should the jury be told whether there is that sentence. As I try to do that with you and for you, I'll probably asterisk a few issues. For example, the first issue I would asterisk is mandatory minimum sentences are themselves a modification in the system, which Judge Devlin referred to. You know, so there's no prohibition upon modifying the system. The only trouble with mandatory minimum sentences is that it modified the system in a very bad way. They're obscene, they shouldn't exist, they take too much power away from the judge. But now we've got this situation where the question, should a jury be told if there's a mandatory minimum sentence? Here's part of the reasoning why I think that they need to be, and then I'll talk about a particular case when they weren't, even though the judge in that case, upon my motion and brief, which can be found on the website, said, I agree with you, but that's not our law, and good luck at the appellate court level. Fortunately, we won the case and we didn't have to go on appeal. But that judge did think that he should have had the opportunity, an enlightened judge, no doubt, had the opportunity, he should have had the authority to instruct the jury on mandatory minimum sentence. Part of my argument, I think this was part of the oral argument, but it's this. There's good reasons why in a case where there's not a mandatory minimum sentence, we have reason to, and this can be debated, but we have reason to believe that when jurors are told that punishment is not their job and it's not their function, their job is to find the facts, and the judge's function is to apply the law, and that includes punishment. I'm not so sure as my thinking is evolving on this subject whether I even agree with that, but that's an asterisk. We're not going to go there. Why should juries be told when the judge doesn't have the authority to impose the sentence, when the judge has been handcuffed by the legislature? And my thinking is something like this. The legislators are the representatives of the people. The people include the people who've been selected for this jury. When the legislators passed this law, and you can test this when you go back out into your communities, that law wasn't promulgated in the sense that we mean jurisprudentially promulgated, that people really know about it. In other words, they passed the law, and by the way, and this is another asterisk, the client in my case was originally charged with burglary and some other charges, burglary in the first degree. Substitute information was filed charging home invasion. And the asterisk is, we've got to revisit that home invasion law. It was passed quickly without proper consideration or debate in a natural response, but not what should be a legislative and measured response to the Cheshire home invasions. It's a bad law. It's so loose that you'll be amazed when you start reading the elements of that crime, not anybody, but how broadly it can be applied. It has a 10-year mandatory minimum sentence. Okay, so now, but get back to the point. That's an asterisk. Back to the point is, if I, as a legislator representing the people, have passed a law on their behalf, and it hasn't been promulgated up until the point that they sit on the jury and they don't know anything about it, then I think within the system itself, they've got a right as citizens and taxpayers of this, where they're sitting, to be told about the law that was promulgated. By the way, it's no longer now a judicial function, it's the legislature, meaning you, the people, your representatives, are in effect sentencing to this person. So they want you to sentence them, they want you to sit, they want you to find the facts, but they don't trust to tell you what penalty you have attached through them to this law. I think that is actually an absurd proposition. I think that for the very narrow purposes of this discussion, without getting into whether they ought to be told the penalties in any other situations, keeping it narrow, when they, the people, are imposing the penalty and the judge is taken out of the situation, then they've got to be told. Now, here's one of the horror stories. This is what got me on this case, on this issue so strongly and passionately. In the case that I had, I represented a young man. The facts were very bad, by the way. The government could make a case, the state could make a case, even for home invasion, if we didn't get a little lucky and blah, blah, blah. But they could, originally, for a year after this guy was charged with burglary in the first degree, carrying, by the way, a 5-year mandatory minimum sentence, that situation prevailed. We had pretrial after pretrial. The prosecutor's offer was 5 years, mandatory minimum. The client wouldn't even consider it. And it was very much an intelligent, educated client. It was not open for discussion with defense lawyer. And then on the eve of trial, because that's what it had come down to, another prosecutor came into the case. And he immediately filed a substituted information charging home invasion a year later. And we went to trial on home invasion, and this guy is now facing 10 years, maximum mandatory minimum. And I went to the prosecutor during the jury selection, and I went to him during the course of the evidence, and I said to him, you don't really believe, not that this guy didn't commit home invasion, by the statute I could see where you would believe it, but do you really believe that this guy should get 10 years? That the judge doesn't have any say about it? That if you do convict him, and I tell you the truth, I'm scared as hell that you are going to convict him. But is that right? And he said, well, just plead to assault in a second. I'll change the charge back. I said, but do you really think, even though he did this crime, allegedly, and in your mind he absolutely did it, do you really think 5 years is fair? Yeah, he said, I think 5 years is fair. Okay, I didn't. Reasonable people, prosecutors and defense lawyers, particularly unreasonable people, can differ on that particular subject. But he clearly didn't believe that the guy should get 10 years. It was only used as a whip. It was only used as a bludgeon. That's wrong. And nobody had anything to say about it. And I tell you, by the grace of God, the guy was found not guilty. I think he was found guilty on maybe damage to property. One of the things he did when he was in the fellow's house was he bought a baseball bat with him and he broke his 52-inch television or something like that. defending himself, of course. But anyway, I don't want to make light of it, and the facts are less important than how important it is to instruct juries on mandatory minimums. That's the only, well, first of all, it goes back to colonial times, not only to civil rights times, where British enforcers were penalizing colonists, arresting them and penalizing and having the draconian penalties that the colonists began to nullify. So nullification is another asterisk. That's a whole other conversation, a good one, an important one. It raises the question of whether or not the jury should even be instructed that they have the right to nullify. I happen to be evolving into the point where I think they should, but that's for another day. And it's better to stick with the much narrower question. I will close with this. I thought when I came up with this idea to request to the judge that they ought to instruct the jury, I thought I had come up with a brilliant idea that nobody had ever thought of before. And then I started to do a little research, and I found that Judge Jack Weinstein, in my mind, one of the most brilliant jurists of any time, of the Eastern District of New York, had written a decision in 185 pages that's traced the whole history of the jury power, why they should be allowed this right, where it comes from, how it's built into the Sixth Amendment, and so forth. So rather than read my brief, which is about 20 pages, I recommend you to Judge Jack Weinstein's brilliantly researched and argued article. And if you can read that and not be convinced that we ought to instruct our jurors, I'll continue to argue it and try to find somebody to agree with me. Thanks very much.
And I should flag that a few other judges around the country have begun to state their views in favor of advising juries about mandatory minimums, particularly in a few federal cases. So Judge Lynch in the Southern District of New York tried to do it some years back. The government in that case brought a mandamus action, and the Second Circuit informed him that he could not do it. Judge Nancy Gartner has an article coming out soon on this issue where she argues in favor of telling juries, and at least in this narrow category of cases where there's a mandatory minimum, that about the penalty. So I think it is an idea that's gaining a little bit of speed here. We'll hear now from Len Boyle, who has practiced both in the federal and state system prosecuting cases.
Thank you. As you can imagine, I part company with Tim on a number of issues, but I suppose the central one for your consideration today is that I don't believe that you can consider the instruction of mandatory minimums separate and apart from the question of jury nullification. Because in my view, instructing juries as to the consequences of their guilty verdicts is, in essence, backdoor nullification. Now, let's remember that when the jury is charged, the jury is told that if the state hasn't proven each element of the offense beyond a reasonable doubt, they must acquit. So if they don't find the charge proven beyond a reasonable doubt as to each element, game's over, everyone goes home. We only get to the point of considering anything further if the jury determines that the proof has shown beyond a reasonable doubt that the person committed the crime, as defined by our elected representatives. If we are to then tell them, but you should know, having found that the charge has been proven beyond a reasonable doubt, these are the consequences of your finding, how are we doing anything other than telling them, think twice, do you really want to convict this person? I just think it is inevitable that that's what we're telling the jury, because they've already decided that the evidence has proven each element of the offense as charged. And now we're simply saying, think twice, do you really want to impose guilt in this particular situation? And if we were to do that, what then does the jury do with that? Presumably, this is going to happen in the guilt phase of the trial. So if we instruct the jury that they don't have to convict, even though they found the case proven beyond a reasonable doubt, because they don't like the mandatory minimum, isn't it then appropriate for the jury to hear why it is that we have a mandatory minimum? our elected representatives, on behalf of us, have made a policy determination based on a variety of factors that certain offenses merit mandatory imprisonment. If the jury is going to be allowed to ignore that, to trump what our elected representatives have imposed, shouldn't they, at the very least, consider all of the same facts and evidence and social issues that went into the legislature's determination as to why a mandatory minimum is necessary? Shouldn't the jury then have to hear the impact on inner-city neighborhoods from crack dealing? Shouldn't juries have to hear the impact on people's lives of home invasions? Shouldn't they have to hear the impact on society of persons who have been multiply convicted of felonies being freed to go back on the streets? All of those social issues that our legislators considered in imposing or enacting a mandatory minimum, it seems to me, would have to go back before this jury of 6 or 12 so that they can say yay or nay. We think that was a good, in this instance, on these facts for this person, we can understand why our elected representatives chose a mandatory minimum and we will impose it. And how do we accomplish that? I see no way that you can meaningfully uphold the rule of law by allowing jurors to consider whether they really want to convict of a mandatory minimum unless we put all of that information before them. And so I suppose the only, as I thought through this further after Tim and I exchanged some emails, and he certainly has some important and significant thoughts on it, I suppose the only way that we could do this would be that the trial would have to be bifurcated. Anytime the state charged a mandatory minimum offense, I assume what we would have to do is to have the jury render a verdict of guilt or innocence on the charge that carries the mandatory minimum, and then after that, we would go to some sentencing phase where at that point, all of this other information could go before the jury, and the jury could make what is essentially a policy determination as to whether they want to impose that sentence on this particular defendant. To me, we've then gone to sentencing by jury. And one of the tasks that Professor Russell gave me was to play devil's advocate with respect to juries imposing sentences, because in our email exchanges, we all expressed some serious concerns about that. So she asked me to play devil's advocate. I think Tim's better suited, given his professional responsibilities, to play devil's advocate than I. But I suppose, I got the advocate part, not the devil's part so much. But I suppose that, perhaps if we accept this notion that the legislature has overstepped its bounds, has already taken too much away from the judiciary, then maybe we ought to consider it. Kevin has told me that he's aware of other states where juries do play a much more active role in sentencing. And I suppose we could devise a scheme, a guideline-type scheme, whereby there would be a presumptive recommended sentence for every conviction, and the juries could be made aware of that presumptive sentence, and then the juries could hear all of the evidence that we are permitted to put before a judge in a contested sentencing, including the defendant's background and criminal history, all sorts of other information that obviously can't be considered in the guilt phase of a trial, and then at that point ask the jury to determine what sentence they wish to impose. I think it would be a tremendously cumbersome system. I think it's a system that would be troubling for defense lawyers because it just gives them even less ability to predict for their clients the consequences they're facing of going to trial. But I do think that if we're going to get into the area of juries being aware of sentences being imposed, we've opened a door that we might as well just kick wide open and walk through. Thank you.
Can I have a brief response or not? Yeah, just that I don't think it addresses the issue of how about promulgating this to the people that represented the people who were on the jury and passed this law. It doesn't address the question of lesser included offenses. It reminds me of the case of State versus Avcali of many decades ago, where a very prominent lawyer, former state representative, was accused of murdering his wife, and he was convicted of murder, and he and his lawyer was instructed, by the way, by him to not ask for the lesser included offenses because he didn't think he could be convicted, and he was convicted. And through years of various kinds of legal motions and so forth,
When the jurors finally got around to being interviewed, 11 of 12 of them said, I didn't think he was guilty, but we thought he did it, and we weren't going to let him go. 11 out of 12 said that, and we were going to punish him for something because he didn't ask for manslaughter. So, and you know, I'm also concerned about the prosecutor using it as a bludgeon. And sometimes the devil is not the defendant. Sometimes it can't, not in Len's case, of course, but sometimes the devil in the courtroom is the prosecutor. And I've run into many, many good ones who I take off my hat to, but enough who negotiate this way and emasculate the defense, and we just need to be protected against that, human nature being what it is.
So one argument for jury sentencing in criminal cases is that we allow juries in civil cases to make decisions about damages. And so why do we permit that kind of calculus to be made? And in fact, in civil cases, we don't even bifurcate, so all the evidence comes in. So why do we trust juries in civil cases and not in criminal cases? We'll hear now from Shelley Sadin, who actually practices in both civil and criminal realms, and in federal and state court as well.
Well, I'm not going to start by addressing the distinction between civil and criminal. I'm going to stick to one and just say that from a defense perspective, jury involvement in sentencing, if you're not approaching it, you know, from an academic viewpoint, but from a criminal defense viewpoint, is really basic. All you want to do, I think, in defending someone is to, I guess an academic would say, minimize the risk of incarceration, and a defense lawyer would say, limit the amount of time that your client has to spend in the hoosegow. And from a defense perspective, there are some dangers, according to, I mean, I don't know a whole lot about jury sentencing because it doesn't happen in Connecticut. The only time it happens is in connection with the death penalty, which I'll talk about in a second. But apparently in a number of states in which there are about a handful of states in which juries still do sentence. There was a tradition of jury sentencing in this country, but it's only left in a handful of states now. And studies of whether or not jurors are more or less punitive than judges have found that juries tend to be more punitive. So from a defense perspective, that worries me for a number of reasons. If all I'm trying to do is minimize risk, I'm not going to want a jury sentencing in a number of cases, particularly things like sexual assault and I mean the kinds of things that people really become indignant about. And that really does get to, we can back up a little bit and think of back to the mandatory minimum question. And juries, I think, I'm not so sure that a jury would necessarily reject mandatory minimum sentences as frequently as we suspect, because I think they can be fairly punitive. But again, just the whole notion of throwing the whole thing open to jury sentencing is problematic because it could increase a client's risk of spending more time in jail. And as Timmy points out, the other problem is that it becomes and again, according to these studies and articles that Sarah sent around, it becomes a tool for the prosecutor because in plea bargaining, in addition to all the other issues that a client has to face in deciding whether or not to go to trial, there'd be the additional question of whether or not the client wants to be sentenced by a judge or a jury. If it's generally jury sentencing, but you can plea bargain that away, it may be that a prosecutor offers you a charge to which, if you pled guilty, you would be sentenced by a judge instead of a jury. So it might be a tool for the prosecution. And the other concern for defendants is that it's less predictable. I mean, any time that you have a decision made by a jury, it's just really much harder to predict what's going to happen. And if you're dealing with a client who's trying to minimize his or her risk, not knowing, not having any real sense of what could result from a jury sentencing can be a problem. I think Len is right that there really is an intersection between the mandatory minimum sentencing and the jury sentencing issue. And if I can just go back to something that everyone has said, that the notion that there is a long tradition of juries being involved in sentencing, it's really long. There's a great book called Verdict According to Conscience. And it's not on the website or anything, but I recommend it to people. It's really great. It's by a guy named Thomas Green. It's a 1985 book. And he discusses the sort of jury involvement in not just deciding guilt or innocence, but in deciding appropriate sentence. It goes back to medieval England, so it's really old. And I think Judge Devlin is right that part of the reason that we devolved into judge sentencing is that when juries were making the judgments about sentencing, they really only had one option. It was for theft, and everything else. It was death, and so you really wanted to have the jury be able to give the defendant any way out from that. And as sentences and crimes became more and more complicated, it made less sense to permit jury nullification. I think that because we now have mandatory minimum sentences, we're sort of moving back in a way to a system in which the sentences might be more harsh than juries would like to impose, and perhaps they really should be given a way out. So that might be an argument in favor of allowing juries to be involved in sentencing to that limited extent. But I think Lynn's right. The problem is, where do you draw that line? And the other question about line drawing when it comes to jury sentencing and mandatory minimums is, if we let juries decide death cases, that they are the sentencers in death penalty cases, how can we draw the line between those and cases where it's a 3 strikes case, they're facing life, it's a 20-year man-min for a 50-year-old guy? It really is a fine line that we're drawing between those cases in which the sentence is way too harsh and those cases with death and those cases in which it's really, really harsh. And just the one observation I'd make about the only time I've ever had any jury involved in sentencing was a federal death case. And it was ugly. I mean, it was a daunting prospect to have a bifurcated trial in which a jury which had just found my client guilty of contract murder was now going to decide whether or not the client was going to be, spend the rest of his life in prison or face death. And you do have, in a bifurcated trial, you have the opportunity to present at the second phase of the trial much more information and background information that they won't have heard at the first phase. But you've got people who've heard nothing but really, really horrible things about your client, and you really are starting from way back, at the baseline, trying to crawl your way back to making the person into a human being. So where I come out as a defense lawyer is that all I'm trying to do is minimize risk. I think there's very little downside for defense counsel to be able to have the jury know about a mandatory minimum, because, if they want to reject it, they can. And if they don't, it's not as though, their power is any different. They could, they're not going to be able to impose sentence. They just can decide whether or not to reject a man-min. So that's not really dangerous. I think jury sentencing really is dangerous. And if you can't come to any principled distinction between the two, I'd rather leave things the way they are.
So one question, I guess, for our defense lawyers here and also in the audience: how would you feel about a system that allowed jury sentencing, but only at the defendant's option? So the government doesn't get to decide, the judge doesn't get to decide, but if you have a particular type of case where you think you could do well with a jury,
personally,
I think
the judges should sentence. I think the legislature should stay out of the judge's business, and I think everybody else ought to stay out of the judge's business, and judges should sentence. But I think juries, like in my case, I didn't know if they were going to find the guy guilty, if they knew the mandatory minimum. I just thought that they were entitled to know that, and also to know the lesser included offenses and make a decision, an informed decision. But I think judges should sentence. I trust a lot of juries more than I trust a lot of judges on the facts, but I trust more judges on the sentencing than I would trust most juries.
Well, that might be partly because Connecticut judges are not, I mean, in federal court, it's always the case that judges are appointed, but in a lot of states, they're elected. I'm not so sure I would want.
Oh, that would also be a terrifying prospect. No, I think we have the best system. We've got wonderful judges for the most part, and they do a great job. I'm just for more information, and I'm for the legislature promulgating what they do so citizens, when they're faced with these kind of choices, really know what the choice is that they're faced with. And I think they're not giving the complete facts. They're not trusted somehow to be able to tell whether or not that punishment fits that crime, when there's a mandatory minimum, when that's been taken out of the judge's hands. If it's in the judge's hands, then whatever the penalty is should be up to the judge.
I'd like to open it up to the audience for questions, comments.
My perspective as a trial judge is that I've spoken to many jurors after a verdict in a criminal case, and the jurors are almost regularly interested in what is the sentence for this particular offense. And I tell them that, of course, we've instructed you cannot consider sentencing considerations or punishment in deciding guilt or innocence. But and presumably they follow that instruction. But the fact is that they are curious about that. They probably have some sense from the title of the charge, murder or sexual assault, fourth. You can probably tell which is more serious. But the fact is they're curious in every case. So my question is, if the proposal is we should tell jurors about mandatory minimums in some cases, and it seems because you may have had a bad experience with that particular sentencing statute. In your case, why shouldn't we tell jurors about the sentence that applies for every crime that's charged?
I don't think there's any reason why we shouldn't. Although I think it is more important. No, I've actually come to that conclusion, and I did have a bad experience. But as far as I'm concerned, the bad experience isn't dictating the way I think about it. It's made me think about it. And it's made me read that 178-page decision by Judge Weinstein, who's a lot smarter than me and who's researched it a lot more deeply, who came to the same conclusion. I had come to that conclusion sort of unwittingly, and then I buttressed my own conclusions with Judge Weinstein's scholarly decision. But yeah, I think that juries ought to know what the penalties are, just for that reason, just because they're always asking. I mean, to me, that's a reason why they should know what the penalties are, because that's treating them like children, not telling them that it's none of their business, but this is the range of the penalty. It doesn't mean they'll get the maximum penalty, but this is the range of it. That's an asterisk as far as I'm concerned, because it takes me off the point that I'm supposed to be here to argue and to talk about, which is the mandatory minimum.
Can I ask Judge Schuman, what has been your experience? Are they surprised? Do they think it's too high, too low?
My experience has been that they have a general notion of what the sentencing range is for a particular crime, but are surprised as to the specific maximum punishment. They're surprised that sentences can be assessed consecutively, so that if there are multiple counts, the total exposure is perhaps sometimes in 3 figures, which is somewhat meaningless given life expectancy. So there's some level of surprise.
I guess I had a question for Tim and Joe. Len's point seemed to me really fair, that this really is so inextricably linked with the nullification issue, it seems to me. And I don't understand what would be the purpose of instructing about a mandatory minimum sentence if it wasn't really essentially a nullification instruction with kind of a win. You know, that you should know the mandatory minimum, because what's the importance of instructing about that unless you're implicitly inviting them not to convict and to nullify if they're troubled by the sentence that will be imposed. And following that, to my knowledge, I think every jurisdiction that I'm aware of has decided against instructing juries about the nullification power. It's this weird thing that we concede, we know that they have it, but we're not going to tell them. So the ones who are smart enough or have somebody who's read about it, who brings it up in the jury room on a very ad hoc basis, it may be applied, but it's very inconsistent because we don't tell them that. And I'm not aware of any jurisdiction that has said, well, we should tell them about the nullification power. So, Shelley and Tim, I'm interested in how do you confront that piece? Or are you just saying, well, we should tell them about nullification?
Well, one of the things, well, I would say that, except you've just told me that it's already been decided all over the country that we're not going to get there.
I'm pretty sure of that.
But I actually do think we should tell them about nullification. I think 999 times out of 1,000, it wouldn't make a darn bit of difference to them. But the one time that it did, they should know about it. Because why have it? It's ridiculous. You know, that you're not telling juries they have this power. You're a juror, you can do this, we're not just not going to tell you can also do that. Okay. But I don't think I'm going to win that argument. So I think that I like it as a prophylactic against the overzealous prosecutor. There are lesser included offenses. In this case, they could have also found the guy guilty of burglary in the first degree, which had a 5-year mandatory. They happened not to, but they had that choice. You know, as I say, how can information to a juror be harmful to the system? If it is that they're deciding that the prosecutor overcharged, he hasn't, you know, there's all these lesser included offenses, they have a place to go. But you know, the thing I can't seem to engage anybody on is that the legislature circumvented the judge. They already said we can't trust judges. Now they're saying we can't trust jurors who we represent in the first place, to whom we didn't promulgate this law. We can't trust them to know it either. So we're sentencing them. That's what I found really offensive. That's right here, you know, that the legislature has usurped not only the judges, which is bad enough. I don't know if judges rolled over on that or they didn't. I know most of the good ones don't like it. I don't know if that, you know, that's also an asterisk. I'm not going to win that argument. That's why I try to make it a narrow argument. I basically said in court, Judge, I don't think that they ought to do this to you, take away this power. But I don't think I'm going to convince anybody here or anywhere, because it seems like it's set in stone now. Someday maybe they'll change it. But I do think I got a shot at this one, so that's why I'm going to be passionate about this one.
Len, did you have something?
I just want to respond to one thing. I think it's a complete misnomer to say that juries have the power to nullify. They don't have the power. There's just not a damn thing we can do about it if they do it. But they don't have the power. The court instructs them as to what their power is, what their authority is, and that's their authority, what the court instructs. The fact that we can't do anything about them nullifying doesn't mean that they have the power. And so I think if you accept the premise that the jury has the power, then Tim's argument makes a lot more sense. Well, if they have the power, we should tell them about it. I don't believe that they do have that power. They could go back there and flip quarters, too. It doesn't mean we should tell them they could do that, even though it's the wrong thing to do. I think that their authority is what the court tells them their authority is, and the fact that they can do things that we can't do a darn thing about doesn't mean that we should somehow countenance that.
I think it's often described in those terms.
It is. They do have a distinction between power and right.
Yeah, well, I don't know if they can do it. What would you
They
call
have
it?
power, but not the right. That's the way it's been described.
It all depends how you define power. Just as President Clinton said, it's always important how do you define is.
Yeah, and when you think about it, I mean, Len, part of the way that the system has prevented jury nullification, even in the cases where they're involved in sentencing, meaning death cases, the solution is to qualify them. I mean, a death jury cannot include on it anyone who would absolutely not impose the death penalty. So if we're going to have if we're going to have mandatory minimum, at least jury involvement in mandatory minimum sentencing in any respect, do we have to start qualifying them for that?
That's a good question. I never thought of that, but maybe in the voir dire we ought to say, would you sit on a case in which you knew the penalty if you found him guilty was going to be 10 years?
Can we do that in a box, or does that have to be done individually?
But I would just
I'd rather do it individually.
to me, the solution to this would be to try to prevail upon the legislature to craft basically escape hatch legislation, which would say if the judge can really articulate a very good persuasive reason, then the judge can deviate from the mandatory minimum. We have that in our drug laws, and that would be highly beneficial. I understand the legislature's point of view. They have their important role to play in terms of the policy in our criminal justice system, and I don't, for one second, denigrate that. But a simple statute that made a high standard for a judge to deviate from those laws, but provided the authority to do that, I think would alleviate a lot of the concerns that defense counsels do have, that they're really up against it. Either, they're faced with, well, you can plead to this non-mandatory, but if you go to trial, I'm going to up the ante to a 10-year mandatory. I understand that that's, there's a certain, sort of unfairness in that notion. I get you there.
Yeah, I know you do.
I saw a bunch more hands.
Hi, Kevin Ferry, 1991 graduate of this university's predecessor, but I do thank Quinnipiac for sending me a diploma. Looks like I have 2 law degrees. But I had a comment to Attorney Boyle about the bifurcation and how that might be a burdensome process. I don't think that it has to be, because the jury's already heard what the wrongdoer, what the evidence is against the wrongdoer. And in a civil case, the only time they get to consider the wrongdoer's conduct really in a global sense is when you're talking about punitive damages. In other words, in a typical civil case, I don't get to say that, Stop and Shop has killed 14 people this year because they didn't salt their walkways. We have to limit it to the facts of the case. So getting into this whole thing about the cost to society and things like that, I don't think that has to be part of it. I think they've already heard what the defendant did, and that should be pretty much the end of it. And the only other thing that I thought about is that perhaps we could have, instead of a mandatory minimum, it would be a minimum. The jury could then decide, does he get the minimum or not? And they're told, if you say or not, then the judge can sentence to more or less. So then it throws it back to the judge's discretion.
And I agree with the latter part of that. You certainly could fashion a system where the jury says yay or nay to the mandatory minimum, and if the jury says nay to the mandatory minimum, now it falls back to the court to go through traditional sentencing. I do disagree, though. I think that given the myriad factors that go into a criminal sentencing, and if we are then asking the jury to apply this sense of the community as to the consequences of this type of criminal conduct, since we have multiple goals in sentencing, including general deterrence to society, then I think that there's a lot of other evidence that arguably should go before a jury in deciding whether it wants to reject what the legislature has presumptively set as the penalty for this type of conduct. But as to the second point, I absolutely agree.
What's that going to do to jury selection? If you open up the door, we're already concerned about the overall time we have with individual voir dire and how we may end up losing the individual voir dire because of excessive questions. If now we have juries involved in sentencing, that's going to open up a whole area of possibly legitimate, not possibly, legitimate questions to ask of prospective juries. And what's that going to do to our jury selection and
But we're all
prolong even more the length of trials that we have.
Well, so far we're all agreeing that juries shouldn't be involved. They should just be informed of the mandatory minimum. The question of whether they should be doing the sentencing really isn't part of this panel's discussion. They shouldn't be. Everybody has said they shouldn't be.
Well, some may disagree.
If they are advised of mandatory minimums, isn't that going to open up the door to questioning jurors as to how, whatever, their background will bias them if we judge the sentences they impose? I mean, it seems to me it has to open up a whole new area of questioning, which will just be one more mess on top of another mess.
or guarantee fairness to the judge.
But if I
can... In 1974, the New York State Legislature passed the Lawlor drug law, you may remember. High mandatory minimums in drug offenses. If jurors were told the mandatory minimum, for example, a female mother defendant, 3 ounces or more of cocaine possession you're going to go away for 25 years to life. People would not have been punished for their offenses. There would have been one after another nullification in effect. And
mandatory minimums are really bad. We are moving in the Judiciary Committee, I think, away from them. Representative Holder Winfield and I had before us last year a highly touted new mandatory minimum on 3 strikes and you're out, where if you were convicted of 3 felonies, you're going to get life imprisonment without possibility of parole. The unbelievable consequences of that were such that in a close vote, after emotional debate, the Judiciary Committee, beat that. So I think we're on the right track. Let's give the power to experienced judges on this. California has got an initiative and referendum system where they've taken the power away from the legislature. Mandatory minimums take the power away from the judiciary. Let's get back and let them do their job.
Just to echo that point, I think one of the real issues might be that these sentences have just gotten so far out of whack with people's common understanding of what might be just punishment, for example, a possession crime. It just strikes me as bizarre that a jury wouldn't know, not that they should know because they're so complicated, what sentence would be imposed upon a person that they find guilty. And one response to the nullification issue might be, I wonder if informing the jury of the consequences of their verdict might lead them to take the burden of beyond a reasonable doubt more seriously. I mean, the notion of beyond a reasonable doubt in and of itself is a little bit strange. You're asking a juror, assuming that you believe that the person probably did it, assuming you believe that if you were betting on it, you would bet that they did it, you need to acquit because it hasn't been proven to you beyond a reasonable doubt that the person is guilty. That it just is a very difficult thing to ask someone to do. It goes against basic human nature of how people make decisions. And so in that way, there's an invitation to nullification in favor of the prosecution inherent in every single criminal case. And I wonder if informing juries of the consequences of guilty verdicts might not act as a counterweight to that and stress to them that the idea of beyond a reasonable doubt is crucially important, something they might appreciate if they understood that there was a 20-year sentence that was going to immediately follow without discretion a guilty verdict.
But I mean, jurors, they're not oblivious to the consequences of their verdicts. I mean, you get a jury in a murder case or a serious sexual assault, they know. Look, they know that their verdict is going to have a severe deprivation of liberty of that defendant. They may not know exactly, but they know. And in my experience, and I talk to jurors too after trials, they're careful. They are careful. So I think this notion that the jury doesn't take into account that there's a real human being that they're dealing with and they hold their lives, that person's life in their hands. In my experience, I think jurors do that in these serious cases. They really do.
Well, the response would be if they know, there should be no debate about telling them.
Let's get a few more comments, though. One in the back.
I was wondering if anybody knew if there had been any challenges to mandatory minimums in Connecticut on the basis of separation of powers, whether the argument would be that the legislature had exceeded its authority by encroaching upon power inherent in the judiciary, and that being sentencing.
I'm not sure it would work because the legislature sets, they set what the maximum sentences are to begin with. So I don't know. The legislature sets the sentencing range as a general matter. They establish crimes. They already are involved to that extent. So I just don't know that the mandatory minimum really presents a different issue.
Yeah, I don't know what it's been done in Connecticut, but I think it's clearly established that it's been held that it's not a violation of separation of powers, unfortunately, but I think that's the rationale.
One comment there.
The issue of sentence, be it mandatory minimum or whatever the sentence is, be available to the jury in order to apply a reasonable doubt standard. Reasonable doubt has got to vary. Human beings make, I mean, the idea that reasonable doubt for spitting on the sidewalk is the same as reasonable doubt for murder is absurd. I think the average person would say, hey, what is a reasonable doubt when you're going to convict somebody of murder is maybe a higher standard than what a reasonable doubt is for a misdemeanor. Even though we don't want to say that, because we always pretend that it's one standard. But in fact, it is one standard, but as applied to different facts, if one accepts that, and in fact we do, because we have much more procedural safeguards for death penalty cases, because we say, oh, we have to be really, really sure, which is really sort of in some sense not logical. I mean, I agree with 100%. But doesn't the effect of a sentence, shouldn't it come in to saying what is a reasonable doubt? If I'm sending someone away for life, reasonable doubt may be smaller if I'm sending someone away for a year. And that's I don't think it's a logical proposition. It's not saying it's not the same standard. It is the same standard, but to say it's a uniform standard is different from saying same. What's reasonable? I think that can it be answered? Can it be answered? Absent knowing what you're convicting the person of.
Time for one
I
more
look
comment.
at that from the other side of the bottle now, in the sense that now we're crafting instructions not to focus on the amount of doubt, but to focus on the amount of certainty. And most judges, I think, are really seriously considering instructing the jury not about how much doubt you have, but are you really firmly convinced of the defendant's guilt? But it is true in our system. It does not make a difference whether it's a minor misdemeanor or the death penalty. It's the same legal standard, which is the highest standard that we have in the law.
But as a practical matter, do juries analyze it differently in a minor misdemeanor case as compared to
I mean, I think they do. I think, like I said before, I think the jurors, in a general sense, are aware of the gravity of the case, and will that affect, hopefully, quite frankly, someone whose liberty is in jeopardy, whether for a small amount of time or a longer amount of time, still has their guilt or non-guilt decided by the same legal standard. But human nature being what it is, jurors probably are a lot more careful in murder cases than they are in minor misdemeanors, sure.
So I guess the argument might be, at least in those cases where the public may not know about the penalty, such in a drug case, you might expect the penalty to be much lower. In that type of case, might there be an instruction? Jeff?
I wonder if the panelists might comment on, because I don't know if we've touched much on this, but to the extent we're uncomfortable with juries actually doing the sentence, why not at least have them do a recommendation or just as an informational device? If we think back to when the federal sentencing guidelines were promulgated, they were based largely on empirical data about what judges had previously done in other cases. But why are we depriving ourselves of very valuable societal information about what jurors would think would be an appropriate sentence in a particular case? Keeping in mind that jurors won't necessarily have all the information about a defendant's criminal history. They won't have all the legislative information about why the legislature has decided to impose a certain penalty. But what's the harm of having at least a little bit more information and asking jurors, at least on the basis of the facts that they know about the case, what would be the sentence that they would impose, knowing that it's not binding at all upon the judge?
Well, from a defense lawyer's perspective, if you're talking about individualized sentencing, I'd be concerned if I'm not allowed to tell the jury about the defendant's background. I mean, it just doesn't make sense to me that they'd be sort of giving a recommendation in the absence of knowing who the person is that they're sentencing. And it gets back to, Kevin Kane's argument about how just take forever. I'm not sure that taking forever is bad, frankly, if you're deciding somebody's fate. But
I think that's such a good answer, because in the first case where you're telling them, you're giving them information so they can make a more intelligent decision. Here you're asking them to make an intelligent decision without all the information that they need to make a recommendation. So I think that I would totally agree with that.
I guess all I would say, Jeff, is that I do think we have to bear in mind that while our discussion here is largely focused on individual defendants and what's fair and appropriate for an individual defendant, and that's certainly the paramount consideration, we've also accepted that of the four purposes of sentencing, punishment, incapacitation, specific deterrence, and general deterrence, the general deterrence concept is critical to the sentencing role. And I don't know that a jury hearing one person's case has I'm sure that that jury has nowhere near the understanding of the general deterrent function that is to be served by sentencing that a judge has. Or in my view, that a legislature has for specific types of offenses that are particularly egregious.
I think in really violent crimes, gang-related crimes, things like that, we asked a lot of ordinary citizens to sit on these juries, and asking them to publicly declare some denunciation of the defendant is it's a lot to ask of them. So they're very courageous, and I'm proud of them. So I just as soon leave it sort of their role as it is now.
Well, I think on that note, we have to draw this to a close. I'm going to invite Jeff up.
Most dangerous place to be at 5:30 on Friday afternoons between about 100 people and a reception with refreshments, good food and refreshments. I just want to thank our panelists again and the Connecticut Bar Foundation, especially our moderators, Mike Lawlor for the first panel, Sarah Russell for the second panel. And it was so clear from today the amount of forethought that each of our panelists put into their presentations. And for that, all of us and our students, of course, are a lot better. So please enjoy the reception. I will, for anybody who is curious about accessing the special forum website, it's not the same as the Quinnipiac University website. I'd appreciate it if you'd send me an email, jeffrey.meyer@quinnipiac.edu. I will send you a link to that website, which not only has the program for today, but all the various, or almost all the various background readings about the very important topics that we talked about. So thank you again to the Connecticut Bar Foundation, the students who worked in this, and all of our panels and participants today. Meeting adjourned. Thank you.